So we are live, we can start now. So, greetings to everyone. I am Ananya Gupta, warmly welcome you all to the technical session 1 of the South Asian Conference on Constitutionalism and Democratic Governance 2026. This conference is being organized under the South Asian Academic Summit 2026 by the Center for Development of Intellectual Property Research, Naovina Development of Intellectual Property and Research Foundation, in collaboration with the International Institute for Democracy and Electoral Assistance and the International Society of Public Law. This conference is not only an academic dialogue, but also a vital platform for advancing constitutional values, democratic governance, and institutional accountability in South Asia and the Global South. It focuses on addressing contemporary challenges such as constitutional blacksiding, judicial independence, electoral integrity, digital governance, and protection of fundamental rights while fostering comparative and policy oriented scholarship. Through this conference, we aim to strengthen democratic institutions, amplify South Asian voices in global constitutional discourse. The Center for Development of Intellectual Property and Research is a premier institution established as India's first non governmental research organization dedicated to intellectual property rights, operating under the Naovina Development of Intellectual and Research Foundation as a registered non governmental organization. CDIPR is dedicated to promoting and protecting intellectual property rights within India, thereby fostering a conducive environment for innovation and creativity. We are a community connecting 2,200 plus members plus 12,000 plus global academicians on intellectual property rights. Our collaborating partner, the International Institution for Democracy and Electoral Assistance, is an intergovernmental organization that supports sustainable democratic institutions worldwide. IDEA works to strengthen electoral processes, political participation, and constitutional design, and democratic accountability across divisions. And the International Society of Public Law is a global scholarly association dedicated to advancing research and dialogue in public law, constitutional law, comparative government. ICON S connects academics, practitioners, and policymakers to promote excellence in public law scholarship. We sincerely thank IDEA and ICONS for the invaluable intellectual and institutional support in making this conference a success. Now, I am honored to introduce our session chair for today, Mr. D.S. Mandal, Executive Member for Center for Development of Intellectual Property and Research. We are grateful to you for kindly agreeing to guide today's session. So, before we begin, I would like to briefly outline the presentation guidelines. All the presenters are kindly requested to note that each presenter will be given a time of 6 minutes, 5 minutes for presentation, 1 minute for questions and comments. Kindly monitor the chat and comment box for timely updates. Please ensure that your microphone and camera are functioning properly. Presenters are requested to strictly adhere to the timeline. Your cooperation will help us conduct the session smoothly. So, we now begin the technical session 1. I take this opportunity to welcome all our presenters and thank them for contributing their valuable research to the conference. And now invite our first presenter, Komal, who can start the presentation. May I request you to kindly begin with your presentation, Komal?
Yeah, sure, please. Hi, can you please confirm if you can see my presentation?
Yes, we can.
Good morning, respected chair and fellow participants. Thank you for the opportunity to present my paper titled Emergency Without Emergency: The Normalization of Exceptionalism in South Asia. This paper examines how emergency powers today often operate without invoking constitutional emergency provisions particularly in South Asian democracies. As the title on the slide indicates, this paper will focus on what I call emergency without emergency. The concern here is not the absence of law, but rather how ordinary law is repurposed to produce extraordinary outcomes without the visibility or safeguards of a formal emergency. To understand why this matters, I begin by revisiting how constitutional law traditionally understands emergencies. On the left, we see that the classical constitutional theory expects that emergency is a constitutional event that is formally declared, temporarily bound, and accompanied by parliamentary and judicial safeguards. However, as shown on the right, what actually happens today is quite different. Emergency power increasingly operate as everyday governance without formal declaration through gradual and prolonged measures and primarily via executive administration. Rights are restricted not by constitutional suspension but through ordinary statutes, delegated legislation, and executive notifications. This leads to the key insight at the bottom of the slide. The law looks for emergencies in form, while power operates through function. Building on this disconnect, slide 3 introduces my central theoretical contribution, diffuse exceptionalism. As shown on the continuum here, emergency power today often lies between normal governance and a full constitutional emergency. Diffuse exceptionalism describes a situation where extraordinary power is exercised through ordinary administrative mechanisms without any constitutional intervention. The emergency is not declared. It is distributed across rules, guidelines, and discretionary decisions, which makes it difficult to identify, contest, or review as an emergency at all. So, rather than asking whether an emergency exists, the question begins how power is functioning. Slide 4 turns into empirical illustration. I use pandemic governance in India not as the subject of the paper but as a case study to demonstrate diffuse exceptionalism in action. During COVID 19, sweeping restrictions on movement, assembly, and livelihood were imposed without invoking Article 352 or other constitutional emergency provisions. Instead, an emergency like governance operated through the Disaster Management Act, executive notifications, guidelines, and penal enforcement, effectively substituting for constitutional emergency provisions but without their safeguards. This shows how extraordinary restrictions can actually exist outside the constitutional framework altogether. Slide 5 addresses the normalization claim. What began as a crisis governance did not fully recede with the crisis. Emergency tools persisted beyond the pandemic, with no statutory sunset clause and little legislative exit review. Executive control over surveillance practices, regulatory discretion, and administrative decision making continued even as the immediate health emergency subsided. This temporary spillover explains how exceptional governance quietly hardens into normal administrative practice. Slide 6 explains why courts struggle to respond effectively. Judicial review is institutionally designed to address discrete actions and identifiable violations, typically triggered by visible events. However, diffuse exceptionalism operates through multiple administrative measures over time with no single triggering moment. As a result, courts focus on the legality of individual orders rather than the cumulative constitutional transformation taking place. This is not judicial abdication, but an institutional mismatch between the event based review and pattern based power. I conclude by closing the loop. Emergency power today operates through ordinary administrative law, delegated legislation, and executive discretion, which replicate emergency effects but without any constitutional declaration. The challenge, therefore, is not the absence of the law, but law's repurposing. If constitutionalism is to remain effective, constitutional safeguards must respond to the function of power and not merely its form. Thank you for your time and attention. I look forward to the questions.
Okay, participant, what are the country model you had taken into consideration?
Sir, I have examined India's pandemic governance, during which India regulated the entire nation through the Disaster Management Act instead of declaring it as a constitutional emergency moment, which gave rise to multiple executive notifications which governed the livelihood movement and multiple other areas which connect to the fundamental rights of the citizens, which can only be restricted during a constitutional emergency.
All right. I have no further questions. We can move with the next participant. Thank you.
Thank you so much, sir.
So the next participant is Panchal Ronak Kumar Kanubhai. So you can start presenting.
Participant, you are not audible. You are facing technical issue, participant. No, like he's not audible. Host, we can move ahead with the next and we will call
Sure,
him
sir.
again.
The next participant is Neha Burne. You can start with the presentation.
Okay. Good morning, respected chair. The paper that is titled that I will be presenting today is Privatization of Free Speech, Social Media Platforms, and the Future of Democratic Discourse. In this presentation, I examine how social media platforms, while privately owned, have become central to democratic communications and how this transformation challenges traditional constitutional understanding of free speech, accountability, and democratic governance. Over the last decade, social media platforms have become the primary arenas for political discourse. They shape electoral campaigns, public opinion, civic engagement, and protest movements. However, unlike traditional public forums, these spaces are owned and governed by private corporations. This raises a fundamental democratic question: when the public sphere is privately owned, who governs speech and by what norms? So, this tension forms the core problem that is addressed in this paper. Now, the central argument, I'm sorry, the central argument of my paper is that we are witnessing the privatization of free speech governance. Decisions that profoundly affect democratic understanding, such as what content is promoted, restricted, or removed, are no longer guided primarily by constitutional principles or public laws. Instead, they are determined by corporate policies, algorithms, and commercial incentives. Traditional free speech doctrine, which focuses on protection from state censorship, is therefore increasingly very inadequate currently. So, if we talk about the public sphere transformation here, to understand the shift, the paper draws a concept from public sphere. So, this is a very small concept by Hagen Ebermas. Historically, democratic debate occurred within regulated institutions such as print media and broadcasting, which, despite imperfections, operated under public accountability frameworks. In contrast, the digital public sphere is AI curated, engagement driven, and fragmented. Deliberative debate is often displaced by speed, virility, and emotional amplification to make something more larger. Now, when we talk here, social media platforms have replaced traditional gatekeeping. While this has lower barrier in participation, it has also produced echo chambers, political polarization, and fragmented publics where content that is generated often works only on the engagement purposes. So, as a result, platforms do not merely host democratic discourse, they are actively structuring that entire discourse. So, this leads to what this paper describes as the privatization of free speech. Platform regulate speech through terms of service, community standards, and automated moderating systems. Yet they are not bound by constitutional free speech guarantees, due process requirements on democratic oversight. So, content moderation practices reveal this democratic deficit very clearly because they are often opaque, inconsistent, and lacking meaningful explanation. Most importantly, users have limited procedural safeguards and weak avenues for appeal, undermining trust and reinforcing uh, perceptions of arbitrariness and very vagueness in that speech. So, this paper examines the evolution of two major intermediaries which are not there in India. First is the Section 230 in United States and EU e-commerce directive provided broad immunity to platforms to encourage innovation. However, modern platforms are no longer passive intermediaries. So this has prompted global regulatory recalibration, something that India needs also need to be a part of currently. So, the European Union's Digital Service Act adopts a right based, risk oriented framework emphasizing transparency and accountability. However, excessive regulation risks chilling effects on free expression, which we are seeing in India also. So this phenomena actually threatening electoral integrity, social cohesion, and public trust. And the entire challenge is focused on how legal it is, how legitimate it is, what is the necessary of it, and proportional. I think balance is still missing. So, coming to AI governance, algorithms determine visibility, reach, and relevance, yet they operate through a very proprietary system. So, this invisible architecture poses a serious democratic concern. So, coming to the due process, a key normative concern is the absence of procedural fairness. This disproportionately affects journalists, activists, and political dissenters, producing chilling effects on our democratic participation. So due process or central to democratic legitimacy is currently what is required. So my idea is that the framework should focus on preserving freedom of speech and expression, ensure transparency and accountability, introduce procedural safeguards, and enable independent oversight. So instead of too much direct state control, it should be constitutional grounding of platform governance. So, to conclude, the privatization of free speech represents one of the most profound constitutional challenges of our time. Neither unchecked platform autonomy nor heavy handed state regulation offers an inadequate solution. So, ultimately, the future of democracy depends not only on who speaks, but on who governs the speech. So, I'm leaving with this thought and I'm open actually to the questions regarding to it. Thank you.
Okay, in India, we saw Section 152 has been brought in BNS, and it
Yes.
is same. It is having the same problem of tackling with the freedom of speech, coming up with the reasonable strict restrictions. So my question to you: does it fall under the reasonable restrictions?
So the point is, if we are talking about reasonable restrictions for something like public or platform, it is fine. But as I talked about that, if we are too rigid or regulated, then where would the journalists go? Because we talk about our entire fourth pillar of our democracy is based on free press, and the censorship actually bounds upon that also. So for BNS to work properly, you need a secondary policy framework which is specially targeting those people whose entire job is to provide the truth, and limiting those people who are creating an entire drama around a political agenda or a scenario and just making it larger for public to hate it. So that is the balance I think I require. So BNS is, I think, just one step forward. We need more policy concerns for reasonable restrictions to work.
Okay, thank you. We can move at the next participant.
Thank you.
Okay, so the next presenter is Ashley Mishra. She can go on with the presentation.
Participant, kindly share your presentation.
Ashi, are you there?
Host, otherwise we can call Pranchal and then we can call Arshi. I believe he is present.
Hello, everyone. Sir, am I audible?
Yes, you
Yes,
are.
you are audible and visible. Yeah.
Sorry for the technicalities. Basically, mm, is my presentation visible, sir?
Participant, you can start. Yeah, you are visible, audible, and your presentation
Uh,
is visible.
Good morning, everyone. My name is Ronak Panchal, and I am an LLM student at Gujarat National Law University, Gandhinagar. The title of my paper is Horizontality of Constitutional Rights in India, Text, Doctrine, and Transformative Potential. As the title suggests, it examines horizontal constitutional rights under the Indian Constitution and propose ways to improve enforcement mechanisms. I will be dividing my presentation into 5 parts, starting with the first part, introduction. As we are all aware, the Indian Constitution explicitly provides fundamental rights that are vertical in nature, means it is enforceable against the state under Article 12 and 32. Uh, However, there are few articles that are horizontal in nature, such as Article 15, Clause 2, 17, 21, and 23. This means they're enforceable against anyone, including private actors, corporations, individuals, etc. So basically, to enforce such rights, the Constitution directs Parliament and Executive to enact appropriate and effective legislations. In summary, basically, the state has positive obligation to ensure that citizens' rights are protected in horizontal relations. Building on this framework, in my paper, I argue that even though other fundamental rights, which that horizontally in the even though other rights are not explicitly horizontal in the text, they must be interpreted in a similar manner, basically binding the state to enact effective legislation. So before delving into the technicalities of horizontal rights under Indian constitutions, I would like to examine judicial evolution of horizontal rights jurisprudence. So basically, my proposed model is not alien to Indian constitutional law. There have been several decisions in which the court has interpreted Part 3 rights as having horizontal applications, either explicitly or implicitly. For instance, in Vishakha versus State of Rajasthan, the Supreme Court laid down detailed guidelines to protect women from sexual harassment at workplace, recognizing the right to work without interference from private parties. Similarly, in Randhir Singh, the court recognized the principle of equal pay for equal work, grounded in Article 40, 16, 39, pursuant to which Parliament enacted the Equal Remuneration Act. Basically, the legislation prevents wage discrimination at the workplace between men and women for similar work, thereby regulating private employment contracts. Further, in Bandhua Mukti Mocha versus Union of India, the court held that Article 21 imposed a positive duty on the state to liberate bonded laborers from economic exploitation by private employers. And more recently, in Kaushal Kishore versus Union of India, a constitution bench recognized that Article 19 and 21 operates against private parties. Basically, they observe that the rights such as the constitutional rights such as free speech, privacy, dignity have a dual character, means they exist as common law rights in private dispute and as fundamental rights enforceable through writ jurisdictions. It was noted that state is under a positive obligation to protect such horizontal rights through effective laws, schemes, and consistent with the values of Part 3. So in summary, my argument is that this judgment basically recognize that fundamental rights in the Indian Constitution also operate in the private sphere, even though they are not explicitly horizontal in nature. They're enforceable against private actors under Article 32 or 226. Any failure of the state to protect such rights or any law permitting the violation can be challenged on the grounds the state has failed its constitutional duties, and same can be enforceable under Article 32 and 226. So in comparative perspective, we can examine few other constitutions. A similar frameworks basically exist in other constitutions as well. For example, in Bangladesh, Article 102. Uh, Under Article 102, Bangladesh courts can issue writs against any person or authority, including private actors, providing even wider protection than in India. The Sri Lankan constitution contains explicit horizontal rights, while Nepal follows a similar broadly similar to that of India. However, the German constitution is particularly significant. German constitutional jurisprudence has basically long recognized the doctrine of indirect third party effect, under which fundamental rights influence the interpretation of private law. Courts are required to construe statutes and contractual relationship in conformity with the values of basic law, particularly Article 1 of human dignity. In light of these mechanisms, Indian constitutional jurisprudence can also be further developed. And how can we develop this constitutional framework? So basically, I argue that in my paper, that this can be achieved through coordinated action by all three organs of the state. The judiciary can lay down constitutional principles through judicial interpretations, and the same can be further enhanced by legislative clarification, constitutional amendments like introducing amendments under Article 12 and bringing private actors within its ambit. Further institutional reforms can also be introduced, for example, empowering NHRC and other legal services authorities to adjudicate complaints against private violations. In my conclusion, basically, I state that the proposed model moves beyond traditional practices, theories such as classical liberalism. It recognizes that private corporations and powerful individuals also exercise significant power and must be therefore be subject to constitutional regulations. As many constitutional scholars have noted, the enactment of constitution was not merely a transfer of power from British to Indian citizens, but a transformation of powers, one that remains incomplete without realization of social and economic justice. With this, I conclude my presentation. Thank you, sir.
Okay, participant, just to mention that an amendment is required in section 12. So what kind of amendment you are talking about?
Sir, actually, I was talking about that the amendment is one of the methods through which we can introduce we introduce horizontal rights under Article 21, under Article 12, for example. So we can introduce that private actors are also part of state, or basically they are exercising significant amount of public resources. They are controlling significant amount of public resources. So basically, we can introduce the amendments and bring them in the ambit of state.
Okay, all right. We can move ahead with the next participant.
So the next participant would be Ashi Mishra. You can start presenting.
Thank you, ma'am.
Ashi, please start presenting.
Yes,
Participant,
ma'am.
your presentation is not visible.
Yes, sir. I'm sharing my screen. Just give me 1 minute.
If it is taking time, we can move ahead with the next participant. So it's an announcement to all again, like all the participants, just keep your presentation loaded prior to your slots. Okay, Ashi, yeah, you
Sir,
may.
is my presentation visible?
Yes, it's getting loaded.
Sir, sir, is my
Yes,
presentation visible?
yes, it is visible. You can start.
Okay. Thank you, sir. So, good morning, all. Today, I'm presenting on the right to disconnect in India, an empirical study of digital work, privacy, and constitutional governance. We are currently at the legislative crossword, the Right to Disconnect Bill 2020-2025, which was introduced by MP Srimati Supriya Sule, which marks an watershed movement in the Indian labor rights. Following the COVID-19 pandemic, and always on work culture has been our could be seen in our economy, which blurring the lines between the professional and the personal life. With Indian workers already clocking an average of 46.7 hours per week, far above the global average, the digital extension of the workday has reached a breaking point, tragically highlighted by recent incident of work-related stress in the corporate sector. So my research seeks to answer if this digital presence justify the constitutional right to disconnect, and how after-hour communication impacts privacy and well-being. The primary objectives were to map communication patterns, analyze impact on mental health, and assess the employee attitude towards the bill. This study addresses a critical research gap. While our constitution protects the privacy, there is a total absence of specific legislation for digital work and a scarcity of the empirical data on the Indian employees' experiences. So we tested several hypotheses, including that over 60% of the employees experience regular after-hour contact, and that over 70% would support new legislation. To test there, I used a quantitative empirical methodology and I surveyed 106 workers across the various fields via an online survey, while the scope is focused on professionalism professionals. The limitation include the sample size and varying the organizational culture across different sectors. So this paper is structured to move from these foundation to a global comparative analysis, followed by our empirical finding and specific policy recommendation. So constitutionally right uh, is a subset of Article 21, the right to life and personal liberty, as constant connectivity infringe upon human dignity and mental health. It also aligns with Directive Principle 1939E and 42, which mandate the state to ensure the human working condition. Internationally, we look at the two models. Uh, France, which relies on negotiating protocols between companies and union, and Portugal, which is more prescriptive, strictly prohibiting the employer contact outside hours. For India, we recommend a hybrid model that provides statutory backstop while allowing for sectoral flexibility. So these were our key findings. So our finding confirmed that 35.8% of respondents receive work communication daily after hours. The dominant tool are instant messaging app like WhatsApp and Slack, creating a constant pressure to respond. The impact on well-being is 80.2% reported negative impact on their mental health. 64.2% report higher, very high stress level. Furthermore, 71.7 of the worker feel they lack adequate time to rest and disconnect. Despite there is overwhelming support for the bill at 77.4%. However, a major challenge is awareness, as 25.5 of the respondents were completely unaware of the proposed legislation. Barriers to implementation include cultural norms favoring long hours and resistance from employees. 60.4% of whom currently have no formal disconnect policy. So policy recommendation and conclusion. So to address this, we recommend a hybrid legislative model with clear definition of the working hour and emergency. Robust enforcement includes the penalty for repeat violation and other sort of protection, gig economy protection, in ensuring that workers are not penalized by algorithm for being offline. Such technology safeguards such as do not disturb feature and email scheduling. So in conclusion, the right to disconnect it's not just a policy preference, it's a constitutional necessity in the digital age. Recognizing this right with align Indian labor law with also with the international standard and ensure that our digital economy remain just human and sustainable. Thank you. This was all from my side.
Okay, participant, recently the labor code has came into existence and it has been enforced. So we see, well, looking into the labor code, labor code, like already the most of the points you had mentioned the recommendation is covered. So are you not agree with the improvements, or let's say the progress in the labor code, or we need more further things?
No, sir. I don't. I'm not agreeing with that. I think we need more laws so as to address this. Since new liberal also are not addressing this issue. More specifically, if we see the working hour condition for the gig economy workers, as also pointed out by one of the MP in Parliament, that uh, they are they are being forced, or they had to respond within uh, that the delivery man has to deliver the product in 30 minutes and much more that to it. So I don't think uh, it's
So
addressing the
participant, like
problem
there
per
is a
se.
difference. Like I want to just make this point very clear. There is a difference between like a time of working hour and the time of production or delivering a service. So you are talking
Sir,
about the delivering of a service and not an working
sir,
hour
I'm
condition.
talking about both. Sir, I'm talking about both the things. So I have also surveyed four of the gig workers. So they said that they have to pick orders and they have to answer beyond working hours also. That's what my survey was about. So I
Okay.
think such
Try to include.
labor law
I
is
will,
not.
I will suggest you to
Please,
include
please.
ILO's gig workers report. You will just get those report in the ILO's website and include in your paper. With the consolidated
Yes,
suggestions,
sir.
it will be more refined. All right,
Sure,
yeah,
sir.
we can move ahead with the next
Sure, sir.
participant.
Thank you, sir.
I now invite Parishi Chaudhary to present the presentation. Parishi, are you there?
Yes, ma'am.
Please start presenting.
Greetings to the panel and my fellow participants. I'm Parishi Chaudhary, and today I will be presenting my research paper on the topic Direct Effect or Imperative Aid Application of International Human Rights Treaties in South Asian Jurisdiction. So, this paper basically examines how international treaties are applied in domestic courts of South Asian jurisdictions. I've chosen India, Nepal, and Bangladesh, and whether these treaties have a direct effect or they apply or work as imperative aid. So basically, international human rights treaties have a binding obligation in international law, but the core legal question is whether these treaties have direct effect in domestic courts or whether they have imperative value. So basically, the objective of my study is first to examine how international human rights treaties are applied in South Asia. Second, to analyze the doctrines of monism, dualism, and direct effect in theory and practice. Then we have to study the judicial trends in India, Nepal, and Bangladesh. Then to assess the democratic and constitutional implications of judicial reliance on treaties, and to finally to identify whether courts follow a middle path often described as creeping monism. Now, basically, this research adopts a doctrinal and comparative methodology analyzing constitutional provisions, statutes, and landmark judicial decisions. And the key findings of this research paper is that all three countries, India, Nepal, and Bangladesh, are formally dualist, meaning treaties require the legislative incorporation of like if international human rights treaties in domestic courts. However, courts increasingly rely on treaties as imperative tools. Now, what is monism? Under monism, it states that international law and domestic law forms a unified system and treaties automatically get enforced in domestic laws after ratification. That is, they don't need to be transformed in domestic law. This monism is mostly common in European jurisdiction but is very rare in South Asian countries. In contrast, dualism states that international and municipal law are two separate systems, two separate bodies, And international law to apply in domestic law, it needs to be transformed as depicted by transformative theory. And dualism is like very common and dominant in
Participant, what are the
South Asian
challenges?
states.
Participant, you can move ahead with the challenges and recommendations thereon.
Okay, sure, sir. But just like, can I give a brief of the practices followed in India, Nepal, and Bangladesh?
Yeah, just to give brief and then move with the challenges. Yeah.
Yes, sure, sir. So in India, India is constitutionally dualist under Article 51C and 253. This reflects the model of imperative expansion and not direct enforcement. Also in landmark judgment of Vishaka versus State of Rajasthan, a Supreme Court used CEDAW guidelines to formulate the legislative gap on sexual harassment. Next in Nepal, so Nepal basically follows like a hybrid model which combine formal dualism with substantive judicial enforcement. Also, in one of the landmark judgment in 2025, Nepal Supreme Court mandated implementation of ILO Convention 169 and UNDRIP. So basically, Nepal follows like it earlier in 1990 Treaty Act. It had quasi monism. Then it had a shift to dualism under Constitution of 2015. Next, we have Bangladesh. So, Bangladesh follows a strictly dualist system with Article 25 merely expressing intent to respect international law. Treaties have no direct effect without legislation, and this has been seen in landmark judgments in Bangladesh versus Unimarine SA Panama and in BNWLA versus Bangladesh. So, now if we talk about the challenges, dualist approach raises concerns regarding judicial activism, separation of powers, and domestic legitimacy. This approach risks judicial activism by allowing courts to effectively direct policy implementation rather than merely interpret law. It also blurs the separation of powers as treaty enforcement and legislative alignment fall within the executive and legislature's domain. Further, democratic legitimacy is questioned. How, when unelected judges mandate broad policy changes without parliamentary deliberation or public consent? While dualism protects parliamentary sovereignty, judicial intervention often becomes necessary to address legislative inaction. The challenge lies in ensuring that courts as guardians of rights, not substitutes of legislature. Now, further, I would conclude by saying that India, Nepal, and Bangladesh remain formally dualist but increasingly use international human rights treaties as imperative tools. While India and Bangladesh exercise judicial restraint, Nepal has moved closer to direct effect in selected cases. That's all I have to say. Thank you.
Okay. What are the policy countries or the models you had taken into consideration?
Sorry, sir. Can you please repeat?
What are the policy model you had taken into consideration for recommendation?
Sir, like if I compare India, Bangladesh, and Nepal, then Nepal has like the best form of policy they've been following. They are the most dualist, and they don't have like the international law, human rights treaties are very properly enacted in domestic law after the interpretation of legislation. So, if I recommend, then I would recommend the policies of Nepal to be followed in Bangladesh, India, and other South Asian
Participant, like for
jurisdictions.
Indian context, we had implemented and ratified UDHR, Universal Declaration of Human Rights, in our Human Rights Act. You can look into the
Yes,
Human
sir.
Rights Act of India. We had ratified it. So how, like, on what basis you are coming up with this that in Nepal or the other countries are having more relevant, because they had also ratified the same thing? In which angle, in which area they are coming up with them much far more better?
Sir, if I talk about Nepal, then Nepal Treaty Act states once a treaty is duly ratified, its terms have equal status with national statutes overriding any conflict. And this statement is also supported by 2015 Constitution of Nepal. So I would say that Nepal, in its domestic laws itself, respects the treaties and also how they have to be implemented in domestic laws.
Okay. See, it's not about just a South Asian context. Take the countries like UK, US, which are come as the as an ideal country for the international treaty ratifications. So looked into those. You can also check up the UNO website where how many countries has been ratified with the domestic laws, or how many countries has been come up with their own dualism or monolism theories. That's how you would be identifying what country is doing up the best. It's not about the South Asian context, like where the international context is required if you're coming up with this type of researches.
Oh, sure, sir. I'll do a follow up on this.
All right, yeah, host, we can move ahead with the next participant.
The next participant will be Aisha Siddiqui. You can start presenting.
Yes, ma'am. So is my screen visible?
Yes, it is.
Okay. Good morning, everyone. My name is Aisha Siddiqui, and I'm a first year BLLB student at NLU Jodhpur. My research explores the friction between the gavel and the variety of the reasons it receives backlash for. So, the core question here is judicial backlash a sign that democracy is dying, or is it just democracy in action? Today, I'll show you why the answer depends on where you are standing and the constitutional provisions of the same place. So, what about the judicial backlash? The duality here is that backlash isn't always bad. In a healthy democracy, we call it contention. It's a check on judicial overreach. But in a failing one, it becomes decay, a tool to silence the court. The key distinction here is if you don't agree with the judgment for a valid reason, it's contention. But if you attack the judge's right to even make the judgment, or you attack the independence of the institution itself, then it's decay. So we'll understand this by comparison between the South Asian context and global context. So first, we'll do a case study of the South Asian context, particularly India, and we'll look towards two judgment: the Work Amendment judgment and also the Governor Stall Bill judgment. So the first argument is the syllabus argument. In India, when the Supreme Court limited the governor's power to stall bills, the executive called the CGI as coming out of syllabus. This isn't a legal critique; it's a patronizing attempt to put the court in its place. Then there was a super parliament argument done by the ruling party itself when the court questioned the Waqf Act, arguing that it interferes with the minority's right to manage the institution, as they were asking for a non-Muslim party also to be in the board, and also a particular officer to check whether the land was actually Waqf or the government land. This also questioned the Waqf by use rule. So ruling party members called Article 142 as nuclear missile, which was used by the Supreme Court in this judgment. This frames the guardian of the constitution as an enemy of the people's will. Then we'll look at the Pakistan and Bangladesh case study. So look at the 26th Amendment. It wasn't just words, it was a structural overtake giving politicians the power to handpick the Chief Justice. This is a great example of democratic decay as politicians are not letting judiciary run independently. Now, this was not just a random amendment brought out by the government. It was because a lot of judgments had been passed by the judiciary against the ruling party itself. Particularly, there was Sunni Ittihad Council versus ECP, where Supreme Court ruled that Imran Khan's party, which was an opposition party, PTI, was entitled to reserve seats for women and minorities. Now, this affected the party, the seat share of the ruling party itself. Then there was the judgment overturning 63A. Earlier, Supreme Court ruled that votes by lawmakers against the party direction wouldn't be counted, but Supreme Court later overturned this judgment. And thus, 26th Amendment was a result of this. Then we look at the Bangladesh context. Contrast this with the quota protest. This was a public backlash against ruling the people felt was unfair. This is a legitimate contestation. The court had to listen to the democratic pulse. Then we look at the Western contrast, where we talk about more about the ideology. The thesis here is in the West, backlash is an ideological war. This could be example by taking the Roe versus Wade and Dobbs versus Jackson case. So the fight here was over the originalism versus living constitution. It's a fight about the ideas or the ideology. It's between those saying right to abortion isn't provided by the constitution, while others say that it's a living constitution and it can this right can be read into the constitution itself. In US, the attack is generally not on the institution itself, but rather because of the ideologies. However, this is wrong to say that in global perspective, the attack or the backlash is always ideological in sense, because in Brown versus Board of Education, the court held that racial segregation in public school was unconstitutional and violating the Equal Protection Clause. And this received backlash by the politicians. They further signed Southern Manifesto saying that they would not follow this ruling. However, the we can also contrast this case with the Bangladesh quota judgment, where after even the Supreme Court later overturned the quota reservation, the executive, the main leader, Sheikh Hasina, ran away from the country itself rather than maintaining the democracy of that country. This is very opposite in this case, where the executive enforced, the President Eisenhower, using federal power, enforced this ruling. This also maintained democracy in a sense. Then I would like to propose the idea of carrot and stick environment in South Asia. In South Asia, the executive holds the keys to the afterlife, the post-retirement, the salaries. In a sense that in UK especially, the salaries are basically directly increased if there is an inflation. But in India, there is no such provision for that. The fact is that the stick is the transfer or the media trial. This leads to judicial evasion, where judges, like in the recent 2025 case in the Waqf Amendment Act, the CGI board out of this case right before he was going to be retiring. This shows that there is a carrot and stick kind of environment in South Asian countries. Now we look at the comparison of the constitutional safeguards. So when we look at this table, we see that there is a good behavior life tenure followed in USA. That means the judge can stay on the seat as long as they display good behavior. There is no particular age requirement that they'll have to be retired by this age. This also kind of provides the protection for the judges themselves, that they don't have to worry about the post-retirement jobs or what will happen with them afterwards. So they don't need to look for the further jobs. While in South Asia, they are dependent on president for providing with them the post-retirement jobs. As I mentioned, that the Ethics Reform Act automatically links to the inflation, and the salaries of the judges are increased by that. Transfers, if yes, so in USA particularly, there is no provision for transfer, but in UK, if a particular judge has to be transferred, the highest judicial officer has to take the consent of the person concerned before transferring them, which is not really there in India. Then from contestant to decay. The logic is that backlash becomes decay when the executive tries to create a committed judiciary. The syllabus is what they make for the
Participant,
judiciary.
you had already exceeded the time. You can just come up with your recommendation and conclude.
Okay, sir. So I wanted to make this point only, like we could introduce good behavior as a part of our constitutional provision, that we should not have a particular fixed age, that this is the age that the judiciary should be retiring at and that backlash is basically inevitable part, and we need to, rather than stopping the criticism, we need to stop the dependency of the judiciary. A good behavior tenure module, independent transfer mechanism, and removing executive control over post-retirement roles would be my recommendation. Thank you.
Okay, is there any country in this earth like having no limitation on the age for the judiciary?
As in global countries or South Asian countries?
I'm talking about globally.
I particularly took the case study of USA. I think in UK there is limit.
See, like when we looked into the judiciary, like it is about the judicial nature. Like we consider insanity, old age, or any kind of ill factor which can hamper the judgment is like not fit for giving or delivering a judgment. So these are the factor which has been determined not only in today's era, but it has been determined like in for decades. If you go
Yes.
and read the Victorian era's principles of how a judge should be, at that point of
Yes.
time also these were the debates, it was pre-developed. In the Napoleon court, when this first judicial system came into existence, that also you can take into reference. So
Okay,
these
sir.
are the factors which were determined while deciding the age limitation of the judges. And
Yes.
again, like when we looked into the age limitation, there is always a concept of average age.
Yes,
So
sir.
in 1990s, the average age of human, what was it at presently? I don't know. But right now in 2026, it is not the same. So
Yes.
average age factor is also to be considered. So take
Yes.
these two references. First is like you would be looking into the historical background, how this doctrine or the limitation of the age has came into existence. Second factor,
Yes.
the determining the average age for present generations of the present context, how it can help in modifying the all like past
Age
rules.
limit. Okay.
And yeah, and the third factor is the South Asian regions, whether South Asia is capable enough to tackle about the growing age factor or the other limitations, or we can come up with some other more standardized procedures.
Okay, sir.
Okay, we
Thank you.
can move ahead with the next participant.
Now I would request Nikita Samdaria to present.
All the participants kindly keep your PPT loaded. Yes,
Start
participant, you
presenting, please.
start with your presentation.
Yeah, so am I audible?
Yes, you can start.
All right. So, greetings. My research is on constitutional maintenance as reflexive. So, that's the idea that I propose in my paper here. So, I'll start with a brief background of the research. So, the reason why I picked this topic was because of the traits of sort of a trend of constitutional retrogression and a democratic backsliding globally, as well as its tendencies has been called in the Indian constitutional framework also. Now, I draw this to a theoretical framework in terms of the ideas of liberal constitutionalism and how its emphasis on ideas like stability, predictability divorces it from more empirical realities and leads to a legitimacy crisis and a sort of stagnation. So, this draws from Carl Schmitt's debate right from there, and then I come to the current ideas. Now, the proposed idea is for deeply divided societies of the global south. That's my sphere of research. It needs an accounting between that strict legality, but also between political grounding, continued contestation, and institutional responsiveness. So, these are the variables that I'll be focusing on in my research. And the objective is to reorient the idea of constitutional change and maintenance as responsive and not necessarily creative, and to show the roles that institutions play in doing this. And this would be done through a reflexive rereading of the Indian constitutional system and how it maintains the constitution. So I'll first deal with a little theoretical idea, and then I move on to the proposed idea of reflexive constitution and how that reflects on ideas of constitutional change, such as the trajectory of the presentation today. So I begin with a theoretical jurisprudential inquiry, wherein I see why is there claimed to be a crisis of legitimacy in liberal constitutionalism as a structuralist idea. So I begin with the history of in my paper. I go ahead with why legality was understood as procedural in the first place, and then of course we touch on the Weber idea, wherein legality is ultimately conflated with legitimacy. And then I move to the Rawlston idea, which is the dominant framework on liberalism, and through his theory of justice, its critique of an assumed fragile judgment on a very selective liberal idea, which was then worked over in political liberalism. And I critique it on the lines of how the backgrounding of certain ideas like religion as irrational comprehensive doctrines is problematic because it pushes things out of the political domain and causes a sort of democratic deficit by avoiding contestation. So, what I try to propose here is that when you try to think of a solution between democracy and constitutionalism, there is no solution as such. but the tensions always play. So I give a critique from Michael Sandel, Carl Schmitt, Dyson-Haas, and Moff over here. So ultimately, what I try to contest over here is legality does not guarantee legitimacy. I give the example of South African movement over here. And then again, how legitimacy cannot be reducible only to legality. I give the example of Bruce Ackerman's interpretation of the New Deal and Reconstruction. And ultimately, I conclude over here as to how legitimacy truly means shared political and ethical commitments, and how the continuous tension will between the material and the formal constitution is important to give meaning to constitutions in the current age. So this is the theoretical idea that I build on. Then I give more real examples in terms of how the modern grammar of constitutionalism has been limited to an idea of rights or judicialization, which is critiqued again for a European male imperialist predisposition, which was situated for the American coming together form of government. But when you look at the deeply divided societies, I critique it in terms of how this theory of constitutionalism is a very majoritarian approach. It does not keep in view the social evils of these so-called developing nations, as they're dominantly called, and the unequal realization thereafter. And from a global south perspective, also how it does not respect their set of values, and how judicialization of politics has always been problematic and continues to be so in times of such rampant judicial activism. So, democracy has become a lost cause because of this disconnect between aspirations of the people in the global south and the standardized hegemonic idea of constitutionalism, which has caused other alternative ideas like authoritarianism to take place. Hence, the idea here is to not privilege any certain features as the idea of constitution, but to let that idea be a contextualized choice based on institutional interaction. So here I give the example of the right to property debate in the Indian context as to how, even though it was proposed as a fundamental right, due to the contextual situations, it was then again read down. Now, the proposed idea is constitutions as reflexive. So, the dominant Eurocentric idea of constituent power as we the people, a homogeneous construct, is criticized on many grounds over here. And I rather claim for constituent power as reflexive, as open, wherein all the exclusions and divisions through the founding evolve and eventually keep shaping the idea of people. So, there's no singular homogeneous idea, but it's an evolving continuous idea which gives voices to the alternatives also. Now I proceed to the main part of the research, which is how this reflexive idea reflects on constitutional change. So I first proceed with the methodological idea of change as such. So we have three recognized modes of change, but when you look at the nature of change, it is deemed to be creative in nature. But what I propose is you need to reorient this as reflexive, as responsive to the transformations of the regime. So here I give examples from maybe the Indian change in the standards of constitutional offensive speech, how they changed over time, not just judicially, but also through legislative and extra legal movements. And in the context of India, I also emphasize on the basic structure doctrine, wherein I critique it because it's deemed
you
as
had
a...
exceeded the time. Participant, you had exceeded the time. You can move ahead
Okay.
to the conclusions and recommendations.
Sure. So I just come to the institutional part, which is on institutional committee, and as to how we need to have extrajudicial constitutional interpretation also. Now I conclude with how instead of alienating or limiting the idea to the founding, we need to look at the shifting locus of marginalization over time. And thus the idea is of a continuous reshaping through a living reflection of the regime and also a coordinated institutional approach as against a judicial dominant approach. Yeah, so that will be it. Thank you.
Okay. So in jurisprudence, we all do have the concept of social engineering by some of the prominent jurists.
Yeah.
When we looked into the constitutional development, not only in the South Asia, but also to some of the developed nations, we see that the reflections to their constitutions are first from the society, then from the people of the country, and then the constitutional makers or the framers of that particular nations where the constitutions are being developed. So it's from the first, like it's not a very primary or like for it's a small concept that a society is looked, it's from the first thing that we had been looking into the society. So what basically the changes or exact changes you want like to looked into, because it is very hard to figure out from your paper.
I'll give an instance of the recent constitution making experience in Chile. So in Chile, in 2022, 2023, they had a very liberal constitution proposed, and despite that being the case, it was rejected in the referendum because even though it's liberal, standardized as per the hegemonic idea, it does not reflect their aspirations, and it was not as inclusive in the constitution making process. So what I'm trying to say here that the standardized idea that you're talking about does not always reflect the needs of deeply divided societies of the global south. So that's what the paper was trying to say, and hence we need an open idea of things where these tensions play, and you don't close them as the founding, as the deemed idea. It can't be deemed to be a truth, but it's an evolving thing which lets voices play through.
The idea, the standard idea which you are talking, does it like sound similar to the democracy, that the idea of masses or the voices of the masses?
The idea of constituent power as we the people is not necessarily a pluralistic idea. It's a singular symbolic idea. So I'm against that the homogeneous construction of that idea. There's a difference in the multitude of the people and the idea of the collective will as a symbolic idea. So I'm trying to differentiate between these two and focus on the symbolic idea and how it can't be a closed idea which makes the founding as the grounding of the constitution.
Okay, what are the country policy model you had referred into?
It's from the global south perspective, so I've given that, and I've also used the examples of US and South Africa to contextualize my assertions, and then of course it's limited on India, so I talk about the Indian experiences through different constitutional frameworks.
Okay, all right, participant.
Yeah, thank you so much.
We can move ahead with the next.
So the next participant would be Jilmin. You can start with the presentation.
Hello. Am I audible?
Yes, you are.
Am I audible?
Yes, you are
participant.
audible.
Well, you can share your presentation.
All right.
Participants, kindly keep your presentation loaded. Those who have joined, all of you.
Can you see my screen now?
No,
Hello?
it's not visible. It's not visible.
All right, just a second.
Participant, it is taking time.
My apologies. I'm unable to upload
Okay.
the file here.
If it is taking time, we can call you next. We can go ahead with the next participant.
All right, all right.
Okay, so next would be Sharmishta. You can start presenting.
Hello. Am I audible?
Yes, you are audible and visible. You can start.
Okay. I will start with my presentation now. Hi everyone. So this paper asks why criminalization in Indian politics exists and persists despite constitutional safeguards and repeated electoral reforms. Instead of treating criminalization as a moral failure of candidates or voters, I argue that it is a structural outcome of sustained state underreach. When bureaucratic institutions fail to resolve everyday grievances, political power shifts from impersonal rules to personalized authority. The central claim of this paper seeks to form a single causal chain out of the four phenomena. Bureaucratic failure produces state underreach. This creates an authority vacuum at the local level. Criminal actors enter politics because they already possess enforcement capacity and informal dispute resolution power, allowing them to substitute for the absent state. Once such actors consolidate authority, the problem then shifts from entry to preservation of that power. Dynastic succession emerges as the most reliable way to transfer its power, the informal power that cannot be institutionalized. Patronage then completes the process by embedding loyalists inside state institutions and apparatus, converting personalized authority into durable long-term political control. So, in my paper, criminalization does not simply mean the presence of criminal cases or legal wrongdoing. It refers to the entry of political actors who possess the capacities for coercion, enforcement, and informal dispute resolution. Capacities that allow them to perform the function of the state that the state is otherwise unable to deliver. Illegality is not incidental, it is instrumental. Criminal actors convert informal coercive power into political authority by substituting for the absent institutions. The empirical trend reflects the mechanism I've just described. Over the last 15 years, the proportion of elected representatives with declared criminal cases has increased steadily. This pattern cannot be plausibly explained by voter ignorance or declining democratic values because the increase is gradual and persistent. India has an extensive formal grievance redressal architecture, but these systems are characterized by delay, overload, corruption, and uneven access. As a result, citizens face high transaction costs while pursuing these formal remedies. Over time, this produces a grievance vacuum at the local level. In such contexts, citizens tend to rationally shift away from impersonal bureaucratic channels towards political intermediaries who promise immediate yet informal solutions. Criminal actors enter politics not because it is morally attractive, but because it is strategically protective. The Electoral Office provides institutional access to policing, prosecution, and administrative discretion, the very mechanisms that the criminal actors are otherwise vulnerable to. Politics therefore converts informal coercive capacity into formal political legitimacy. In contexts where enforcement is weak, established politicians deliberately engage in or display criminality as a way of signaling that they possess the power to get things done. They communicate to voters that the politician can bypass institutional delay and deliver outcomes through personal authority. This intensified citizen politician interaction and concentrated authority in the hands of an individual politician is highly personalized. It rests on reputation, it rests on networks and informal enforcement capacity rather than formal office. This creates a structural succession problem because personalized power cannot be reliably transferred through bureaucratic rules or party procedures. Familial succession emerges as the most reliable solution to this problem. To sustain power over time, dynastic actors diversify their control across economic, political, and coercive assets. Diversification transforms personalized political authority into a multi-dimensional resource space spanning finance, enforcement, mobilization, and institutional access. In dynastic settings, patronage allow ruling actors to informally capture state institutions and redistribute the administrative and coercive resources as political assets. By anchoring patronage to stable social groups, dynastic actors reduce electoral uncertainty and reproduce the political support across generations. Loyalists embedded within the bureaucracy and coercive apparatus function as enforcement mechanism, safeguarding dynastic interests regardless of formal shifts in power. Patronage thus completes the causal chain by institutionalizing personalized rule within the very institutions that are meant to constrain political authority. Thank you.
Okay, what are the challenges you looked into for the democratic policies in South Asia?
Uh, like the challenges, the institutional failure that I'm talking about.
Yes.
Yeah, so when I was looking at this question, I was thinking of, um, for example, the state that I belong to. UP in UP from Aligarh, the Lucknow High the Allahabad High Court is like 530, 540 kilometers away, right? And the Haryana High Court is much closer to that. So I wanted to see how the local people are able to, even if they are able to access the institutional uh, the service that the state is supposed to deliver, um, like suppose you have a local dispute with your neighbor, your gram panchayat, your sarpanch is supposed to look into it. So I was thinking, or suppose you have a problem with um, some scheme you're not able to get from the government, then your executive, your bureaucracy is supposed to look into it. So that is the thing that I'm trying to look at, that the executive is not able to penetrate into the people lives, because it is characterized by, again I said, delay, overload, burden, corruption, etc, etc.
So the problem is specifically for India, or you had also looked into the South Asian specific?
So my study as of now is for India, because I have seen all these problems growing up. But I would like to further my research if it's relevant to other South Asian countries too.
To make a comparative study of the South Asian regions and try to include some of the policy models which has been implemented in a ideal country state.
Right.
All right, we can move ahead with the next participant.
Okay, now Jilmil can present if she is available.
I'll present next if possible. I'm still facing
Yeah.
issues uploading the file.
Okay, no issues. So now I would like Shreya to present next.
Good morning, everyone. Um, just give me. So, artificial intelligence today is no longer a neutral tool. It increasingly makes decisions that affects who gets welfare, who's policed, what speech is valid and visible to the public, and whose data is surveilled. When even AI developers have warned us that that this can destabilize democracy. Constitutional questions about AI can no longer just be treated as theoretical. So our paper examines whether constitutional morality rooted in articles 14, 19 and 21 specifically can meaningfully constrain AI governance in India. So India is rapidly deploying AI in both the public and private sphere. But without a robust right-based framework, we don't think that this can be governed. This is being governed properly. So this creates four problems: algorithmic bias, mass surveillance, opaque decision making, and exclusion, especially in terms of the welfare and policing. So, for example, the algorithmic verification in schemes like PM Kisan has led to the exclusion of numerous farmers, and this is despite being eligible beneficiaries due to some sort of data mismatch. And this leaves them without reasons or a way to appeal this, because most of the time, due to their level of education, they might not even know what has gone wrong. So, constitutional morality is what we are using as a basis to sort of understand whether AI is being used properly here. So, constitutional morality refers to the fidelity to the values and spirit of the Constitution, not just the social morality. It operates as a sort of normative compass. When constitutional text is silent or indeterminate, then we believe that this is the spirit of the Constitution should be used. Um, its core values: dignity, autonomy, substantive equality, and rule of law. In quotes, it would enable transformative constitutionalism. So, this means protecting minorities and restraining any majoritarian excess. This matters for AI governance because algorithmic decisions cannot be treated as value neutral. They must align with constitutional norms and democratic accountability. So one of the cases we referred to was Keshananda Bharati. In this, we said that the parliament cannot destroy as it was held that the Parliament cannot destroy the Constitution's basic structure, including fundamental rights and rule of law. And although AI is not mentioned in the Constitution, the doctrine is crucial. It means technological governance cannot bypass the constitutional limits. Any AI system used by the state must comply with the Constitution's basic structure. Efficiency or innovation cannot be at the cost of our fundamental rights. Next we refer to Navdeep Singh Johar. In this case, basically we have taken the part where it says that constitutional morality must prevail over the social morality, which would ground our rights in dignity and autonomy. That when applied to AI, we are specifically saying that systems that reflect social bias, for example, um, cannot be justified simply because they mirror prevailing practices. Constitutional morality would act as a shield against majoritarian bias encoded into the technology. Next, Article 14. Article 14 has evolved from formal equality to substantive equality, where arbitrariness itself is unconstitutional. So AI systems often learn from the historical data with which they are trained. And if this data is biased, it would lead to the production of discriminatory outcomes, while it would appear to be neutral because it is not a human, essentially. For instance, we saw this that Amazon had scrapped its AI recruitment system because it was systematically penalizing women applicants after learning from male dominated data. As the Supreme Court held, equality is the antithetic to arbitrariness. Opaque black box AI decisions in welfare, hiring, or policing therefore violate Article 14. Next, the impact on free speech. AI now governs our free speech too through automated moderation, takedowns, and content tracking. We can see this in terms of social media and the news we see. If the AI sees something that might even be satire, they might consider it to be hate speech and it would limit its visibility. And to a certain point, this is even impacting our free speech and our access to information. We AI-driven censorship based on the opaque risk scores or
Even
automated.
the recommendations and suggestions.
So we are recommending that there be a digital rights commission that is established. So basically, the concept of human in loop, right? We are using AI, but and that is good. We have to get with the developing times. But we're saying that there should be a human in loop, which would be the Digital Rights Commission, who would basically be overlooking this. And as of right now, our hypothesis was partially disproven, where we said that we can go merely by constitutional provisions. We think that that should be the basis, and based that there should be a proper framework and maybe some laws that can be passed. But as of right now, we're recommending a digital rights framework. Because the question is not whether India will use AI, it's whether AI will strengthen the democracy that we have, or it would lead to the erosion of it.
Okay, what are the solution mechanism according to you that the countries should adopt for this?
As of right now, we are saying that there could be better, the information that is the AI is trained with that can be improved and more closely monitored. Next, we have maybe just we do expect that we acknowledge that our knowledge in this might be lesser as compared to a technical person who would know exactly how the AI could be trained better. But we are essentially, as of right now, just criticizing that and analyzing that right now it's being applied, but the way it's being applied is not with full information, essentially.
All right, we can move ahead with the next participant.
Thank you.
And the next participant would be Mahija. Are you there?
Yes. Am I audible and visible?
Yes, you are. Please start presenting.
Yeah, just a second.
All the participants who have joined now, kindly make your presentation loaded without any delaying.
So is it visible?
Yes, it is visible. You can start.
Okay. So good morning. So my paper is titled Beyond the Right to Live, Constitutional Dignity and End of Life Autonomy in South Asia. So this paper examines how Indian constitutional law has understood dignity at the end of life and why similar recognition is largely absent in other South Asian countries. And this study is largely comparative and focuses on constitutional interpretation rather than a moral debate. Most constitutions protect the right to life. Traditionally, this was meant for protection against unlawful killing. But however, with advances in medical technology, life can now be prolonged even when recovery is impossible. This has raised important constitutional questions about dignity, autonomy, and the limits of compulsory life preservation. So, the central question of the research paper is why Indian courts recognized a limited right to die with dignity, while other courts in South Asia have remained largely silent. So, before going further, it is important to clarify what the right to die with dignity mean and it does not mean. So, it does not mean suicide or active euthanasia, both of which remain illegal. It refers only to passive euthanasia, where life sustaining treatment is withdrawn in case of irreversible illness under strict legal and medical safeguards. And Indian courts have clearly separated suicide from dignified dying. So, Article 21 was not always understood as a dignity based right. Initially, it was interpreted narrowly, focusing only on lawful procedure. And over time, Supreme Court expanded its meaning to include fairness, dignity, and personal autonomy. So, this gradual evolution made it possible for courts to later consider dignity even at the end of life. So, the earlier judicial engagement of end of life cases focuses on suicide mainly. In Jian Kaur, the Supreme Court clearly held that there is no fundamental right to die under Article 21. However, the court also recognized that dignity does not disappear at the end of life. It distinguished suicide from dying due to illness and it left the stage open for upcoming cases. So, in Aruna Shanwa case, the Supreme Court for the first time permitted passive euthanasia but under strict court controlled safeguard. Then the case of common cause went more further. It held that right to die with dignity is a part of Article 21. It recognized passive euthanasia and allowed advanced medical directives or living wills. This transformed dignity from a mere abstract into a workable constitutional right. So, when we look across the other South Asian countries, we find that most constitutions protect the right to life. However, none except the India have a judicially recognized right to die with dignity. And this absence is best understood as constitutional silence and not moral opposition. So, this divergence between India and other South Asian countries reflects the different judicial roles or interpretations uh, while having similar constitutional frameworks. Indian courts have actively interpreted dignity autonomy, while other courts in South Asia countries have exercised restraint and leaving such questions in the hands of legislature. So this difference is more interpretive and not cultural or moral. So, in conclusion, and in answer to the research question, Indian courts recognized a limited right to die with dignity because Article 21 has been interpreted as a dignity and autonomy based right and allowing judges to address the end of life suffering through case by case. And courts in other South Asian countries have remained silent because they have adopted more of a restrained approach, choosing not to expand this right beyond its traditional meaning, leaving such questions to legislature. And as a result, India shows judicial recognition at the end of life, while the rest of South Asian country marked by constitutional silence. So thank you.
All right, shall I begin?
So, sir, can we move to with the next presentation?
Yes, we can move to the next presentation. I don't have any question for you. Yeah.
Okay.
Okay.
Thank you.
So, Jimal, you can
Okay,
start now.
all right. So, democracy is universally regarded as the most legitimate form of political organization, since it rests on two core commitments that are collective self rule and political equality. So, individuals express their preferences through elections, and the resulting outcome authorizes political power. And constitutional theory largely proceeds on the assumption that this process is capable of producing coherent collective outcomes that can justify authority. But my paper changes that assumption. I argue that democratic backsliding is not just the result of executive abuse, but a structurable vulnerability built into democratic decision making itself. To show this, I analyze democracy as a formal system of collective choice instead of a moral ideal. So, I'll start with the simplest illustration, the Condorcet paradox. It shows that even when voters are perfectly sincere and rational, majority rule can fail to produce coherent collective preference. Imagine three policy options A, B, and C. A majority prefers A over B, another B over C, and another C over A. Each individual voter is consistent, but the collective outcome becomes cyclical, and there is no option that commands stable majority support. It shows that incoherence does not arise from corruption or manipulation, but it arises under ideal circumstances. Now, one might respond by saying that electoral design can solve this problem, and democratic theory has often taken this route, but formal analysis suggests that preferential and rank choice systems don't eliminate indeterminacy, they just relocate it. Outcomes under these systems remain highly sensitive to agenda control, meaning that changes in the sequencing or alternatives can change results without any change in voter preferences. These systems are also vulnerable to strategic voting, where voters rationally misrepresent their preferences to influence outcomes. Now, these insights culminate Kenneth Arrow's impossibility theorem, which establishes a universal constraint on democratic aggregation. Arrow showed that no decision making procedure can simultaneously satisfy a set of minimal democratic conditions, producing a coherent collective ordering. The failure of collective rationality is therefore unavoidable. Now, additional results will reinforce this conclusion. Like the Gibbard-Satterwhite theorem shows that any non-dictatorial voting system with three or more options is susceptible to strategic manipulation. And together, these results show that democratic indeterminacy is not remediable through better design. Now, if elections cannot reliably disclose a determinate popular will, then electoral outcomes cannot exhaust the content of democratic legitimacy. This helps explain democratic backsliding. Executives are structurally advantaged in this context. This brings me to constitutionalism. Constitutionalism operates as a compensatory framework that stabilizes democratic governance. It does it in three ways. First, it supplies continuity. Elections are episodic, but governance must persist across time. So, constitutional structures preserve core commitments beyond transient majorities, preventing democratic responsiveness from collapsing into institutional volatility. Secondly, it provides constraint. By dispersing authority and limiting the scope of political power, it prevents electoral success from becoming unchecked dominance. Thirdly, it supplies coherence. Where aggregation cannot produce consistent outcomes, constitutional interpretation offers a different kind of order, one based on reason giving principle justification and institutional continuity. And to conclude, I'll just say that democracy remains morally indispensable. Its mathematical incoherence does not amount to political failure. What fails is the assumption that legitimacy must rest on coherent aggregation alone. So, constitutionalism endures as the institutional form through which democracy remains governable when its own logic cannot deliver coherence on its own. Thank you.
Okay, so participant, what are the major challenge you looked into? in your paper?
The major challenges in democracy.
Yes.
The major challenge is what I explained through the theorems of Kenneth Arrow and the impossibility theorem, that mathematically and logically democracy is impossible, since any form of preference aggregation will not lead to a democratic outcome that is not dictatorial in any way. Like, it will have to have one of these things.
All right. So, host, we will be going next with Harish.
Okay, sir.
And a small note to the participant, those who are joining, without calling their name, kindly leave. We will be not taking up your presentation now. So once your name is called in waiting room, yes, Harish, you may present your presentation.
Yes, sir. So, good morning, everyone. I'm Harish, and I will be presenting about demographic discipline and demographic disadvantage, an analytical study on delimitation and representation crisis of Southern India. So, about introduction, this presentation deals with the issue of delimitation and its impact on democratic representation in India. Delimitation is the process of redrawing an electoral constituencies based on population. The main purpose of this is to ensure that vote of every citizens are have equal value. However, in a country like India, where population growth differs widely across regions, the system creates certain imbalances. Southern states are now facing disadvantages because they have successfully controlled population growth. Background of delimitation freezing. After independence, delimitation was carried out regularly after every census. To maintain balance in representation, however, in 1971, delimitation was frozen based on the census data. This freeze was later extended by the 84th Constitutional Amendment in 2001 and will continue until after 2026 census. The intention behind the freeze was to encourage family planning and population control. Instead of solving this issue, the freeze only postponed the problem of unequal representations. So the main research problem lies in the population-based allocation of parliamentary seats. States with higher population will gain more seats in the parliament, whereas states with slower population growth have a risk of losing their representation in the parliament. Southern states have achieved demographic stability through good governance and welfare policies. Despite that, they may have lost Lok Sabha seats after 2026, raising concerns about fairness in federal democracy. And objective. The study aims to examine the constitutional framework governing delimitation in India. It seeks to analyze how population based delimitation affects southern states. It also studies the impact of prolonged delimitation, freeze, on representation. Another objective is to understand demographic trends and their political consequences. Finally, the study explores alternative models of representation used in other countries. And the hypothesis uh, when delimitation resumes after 2026, the southern states are expected to lose around 10 to 15 percentage of their Lok Sabha seats. At the same time, the states with higher population growth will gain more seats. This leads to a shift in the political powers between north and south states, and the voter to representative ratio becomes unequal across regions. As a result, the principle of equal representation is weakened in practice. Reduced parliamentary representation directly affects democratic participation. Southern states may find it difficult to influence national legislations and policy making. Hence, the democratic fairness is compromised in long terms. Democratic performance of southern India. Southern states such as Tamil Nadu, Kerala, and Karnataka have achieved low fertility rates. This is mainly due to better education, healthcare, and social welfare policies. Women empowerment and access to healthcare played a major role in population control. In contrast, many northern states continue to experience high population growth. Delimitation based purely on population fails to recognize these governance effects. Key findings. The findings of my research paper is that pure population-based delimits creates regional inequity, and southern states are structurally disadvantaged. Federal balance is weakened post-freeze. Governance outcomes are ignored in representation, and the reform is constitutionally necessary. So my recommendations will be Lok Sabha seats should be increased and expanded to observe demographic shifts. It also recommends strengthening the Rajya Sabha as a true federal chamber. A permanent and independent delimitation commission should be established. Governance indicators such as fertility rate should be considered in seat allocation. States that maintain demographic discipline should be rewarded and not penalized. And so, conclusion, delimitation is essential for democracy, but cannot be based solely on numbers. Uh, India's diversity requires a balanced approach to representation. Democratic fairness must go hand in hand with federal equity. Without reforms, post 2026, delimitation may deepen regional inequalities. Therefore, a recalibrated delimitation framework is necessary to protect the constitutional values of the Indian democracy. Thank you.
Okay, when we looked into the laws related to delimitation, it's directly proportional to the population of the census. So in India, our census has not been done from 2011. So whether it's a violation to the constitutional principle.
So they have done a delimitation freeze, so the census is not taken yet, and it will be taken after 2020, I guess 2027. So for the region, so reduce the regional disparities, we should be focusing on increasing the seats of the Lok Sabha and give proper portion of the seats to the southern states to manage the clash between the north and southern states, and also help improve the voice of South states about their reforms.
All right. Yeah, we can move ahead with the next participant.
Thank you, sir.
So next participant would be Sana Alvi. Are you there? S Alvi, Sana Alvi. Okay, so next we can have Soumya Pandey.
Hello,
Soumya,
good
you can
morning.
start presenting.
Okay. So, as you can see, my no, you can see my topic is related to LGBTQ plus rights and constitutional recognition in the India, persistent challenges in the marriage, equality, adoption rights, and beyond this. The Article 14, 15, 19, and 21 of the Constitution guaranteed equality, non discrimination, freedom of expression and speech, and the right to life of personal liberty. In India, the Constitution recognized of LGBTQ rights under these articles a doctrinal victory, affirming sexual orientation, gender identity, privacy, and dignity of these citizens. In the year of 2014, the case of Nalsa versus Union of India, gender identity recognized under these articles. On September 2008, the Supreme Court in Navtej Singh Johar versus Union of India declared the judgment that changed India forever under IPC section 377 was partially decriminalized. For the first time in the independent Indian history, LGBTQ and individuals could legally live without fear and imprisonment. The Justice Deepak Mishra word encroached constitutional permissions. The right to choose a life partner is integral under Article 21. It guaranteed for personal rights. Court also declared that it's decriminalized. Uh, when we talk about their rights related to certain things, first we have to talk about adoption right. That in Juvenile Justice Act 2015 required that adopted parents to demonstrate 2 years of stable marriage status and requirement for same-sex couple could not meet. In Hindu Adoption and Maintenance Act 1956 uses guaranteed language that husband and wife, rendering same-sex couple invisibles in adoption law.
In Surrogacy Act, we also see the legally married couple will also have right to access for surrogacy. But in case in LGBTQ individuals, they are they are belonging to same sex or same are some other kind of sexes, so they have not right by the constitution and by some other laws. Then in over 50 countries had already discriminated the same-sex relation in India in joined in 2018, ending the legacy of colonial operations. In 2023, Supreme Court deal the stunning below of marriage equality. A five judges bench rejected the right to same-sex couple to marriage. The court acknowledged that LGBTQ individuals deserve freedom to choose partner and their discrimination and without any legal discrimination yet denied them the marriage. But after certain time, their right related to adoption, pensions, child marriage, these type of right, we have to analyze that they are also a citizen, they are also a living human being, and they have also the human right to present themselves as they are. Yes. And the current status in February 2024, the Indian government formed a high-level committee to examine the LGBTQ right and constitutional entitlement, a step forward accountability after year of inaction. In Tamil Nadu, and some progressive states have begun drafting amendments to adoption laws and recognition framework showing that changes is possible. Constitutional idea of equality, dignity, and personal autonomy must translated into legislative reality. The court point the way parliament must walk the path. Thank you.
Okay, what are the constitutional framework models you had looked into from the other countries?
Uh, Sir, in US, we can see there are certain rights they given by the Constitution. In Ireland, also there are certain rights for LGBTQ, and these changes in India also come by other countries. In 2018, we can see that lots of changes are coming in our country by the constitutional right, by the judgment of the court.
All right.
Okay.
We will move ahead with the next participant.
Thank you, sir. Thank you, ma'am.
Okay, so the next participant would be Rajan Dahia. Okay, so the next participant would be Shinjini Namhata.
Am I visible and audible?
Yes, you can start presenting.
Thank you. Good morning, respected chair, and to one and all present. My name is Shinjini Namhata, and I'm an LLM student in NLU, Odisha. Today, I would like to present my paper titled The Evolution and Migration of Constitutional Amendment Limitations, a comparative study of Germany's Eternity Clause and India's Basic Structure Doctrine. The focus of this paper is on transnational constitutionalism, how the constitutional ideas travel across borders, and how they are transformed to meet local democratic vulnerabilities. The research begins with a very fundamental constitutional question. How can a democracy evolve over time without destroying itself in the process? Now, Germany here offers a very stark historical answer. The Weimar Constitution of 1919, which was very progressive, but it allowed constitutional amendments with relative ease under Article 76. Now, this procedural openness was exploited by Hitler, most notably through the Enabling Act of 1933, which he used to legally dismantle the Democratic Republic. Germany again rebuilt its constitutional order in 1949 when the framers introduced Article 79 Clause 3 of the Basic Law, which is prominently known as the Eternity Clause, which placed certain principles beyond the scope of amendment, which included human dignity, democracy, federalism, and the rule of law. On the other hand, India was facing a different but related constitutional crisis during the late 1970s, which is the tension between the parliament's amending power under Article 368 and judicial review. Now, at this moment, a German constitutional scholar, Professor Dietrich Conrad, was speaking at BHU. He warned that unlimited amendment powers could replicate the Weimar tragedy, which could turn India into what he described as parliamentary dictatorship. Now, his core insight was very simple. If the parliament, which is a constituted authority, could rewrite the very principles from which it derives its legitimacy, the constitutional supremacy would turn into legislative supremacy, and thus came and developed the idea of implied limitations. These ideas directly influenced the case of Keshwananda Bharti versus State of Kerala, where the Supreme Court articulated the basic structure doctrine. Now, my research therefore explores how the idea of limiting constitutional amendments migrated from Germany to India, how it transformed across civil law and common law traditions, and how both the systems today seek to protect democracy. As I move forward, this study addresses these three central research questions, and methodologically, the research adopts a comparative and doctrinal approach, tracing the flow of constitutional ideas from Weimar's failure through Conrad's theoretical intervention and finally India's judicial innovation. If I talk about the key comparative insights in this transnational constitutionalism, first, the source of limitation differs, as is Germany's limitation is textual, whereas India's limitation is judicial. Now, this difference reflects the civil law preference for codification versus the common law reliance on judicial interpretation. Secondly, the judicial application differs. In Germany, the FCC, the Federal Constitutional Court, applies the eternity clause in a largely preventive manner. That is, the eternity clause functions as more like a preemptive shield, which stops constitutional erosion before it even occurs. As I may cite an example, in the Lisbon Treaty case, which is a case of 2009, the court held that European integration cannot dilute Germany's democratic sovereignty. On the contrary, India's experience is more reactive and interpretive. Now, through these ideas and through several cases, as I have discussed in my paper, India's doctrine evolved into a dynamic constitutional safeguard, responding to political crises as they kept on emerging. Functionally, both the systems pursue the same goal, preventing majoritarian destruction of constitutional identity. So there is a functional convergence, but methodological divergence. Now, coming to the main findings of my paper, there are three core normative findings. Firstly, both the doctrines are products of historical trauma. Germany's eternity clause was a conscious response to fascism, whereas India's basic structure doctrine was a judicial response to the parliamentary overreach during 1970s. Secondly, the civil law versus common law distinction explains their form. When Germany's model provides certainty and stability, India's model offers more flexibility and resilience. Thirdly, both the concepts demonstrate that constitutional unamendability is not anti-democratic. It is more like democracy's self-defense mechanism. Of course, to talk about the risks, each of the doctrine has its own risks. India's open-ended doctrine may invite judicial overreach, whereas Germany's rigidity may constant democratic evolution. Now, to conclude my presentation, this comparative study shows that constitutional amendment limitations are not deviations from democracy, but mechanisms for its self-preservation. Now, what is most significant is the transnational journey of constitutional ideas. In an era of global democratic backsliding, this dialogue between constitutions reminds us that power to amend exists for preservation and not for destruction. Thank you. That will be all from my side.
Okay, so what is your lessons from the South Asian context, if I had to ask you?
So I have did this research more on the context of India because it's more of a legal translation as we read in the comparative studies of law. So we have the concept of mirror theory of law, that is, law reflects the society where it is. And in this research, I have stressed that the how a concept emerged as a whole from a Western country to a South Asian nation, and how the translation was more like a cultural approach to comparative law and not functional approach. It adapted in the context how it should reflect the societal tensions, the political tensions, and the legal aspects which exists in India. So to answer your question, I have covered as a whole only the Indian aspect and not explored. This might be a limitation of my paper that I have not explored all the South Asian nations, but I have more like chosen a niche aspect of India comparing with Germany.
All right. Thank you for your presentation.
Thank you, sir. Thank you.
Next, we
We
can
can move
have
ahead.
Unav Raj to present.
Yes, participant, you
So
can
good
start.
morning. Good morning. I am Unnavraj. Today's presentation is where how I examine how traditional equality frameworks, especially in India, fails to address the lived realities of people who experience discrimination not on only one ground but on more grounds at a same time. The focus today is on intersectionality and why single access equality is inadequate and how constitutional and legal frameworks can be reorganized to respond the overlapping forms of disadvantages. If we move that, these are the contents of what I'll be explaining today. So the concept of intersectionality originates from the Black feminist scholars, particularly the work of Kimberly Crenshaw. It was developed to highlight how Black women experience of discrimination were erased when law traced race and gender as two separate identities. Intersectionality is not about creating new categories, but it is about analyzing how systems of operation interact and produce unique vulnerabilities that can be understood in isolation. Moving ahead, why the single access equality framework asks very narrow question whether discrimination occurred because of only one protected characteristics. This approach fails groups such as a Dalit woman or a disabled Adivasi person or a queer religious minority person whose discrimination arises from multiple or intersecting identities. As a result, such individuals often fall through constitutional and statutory gaps, rendering equality protection which is incomplete in this condition. So, moving ahead with the Indian constitutional framework, Article 14, 15, and 21 are the core equality jurisprudence. While 14 promotes formal equality, 21 emphasizes on dignity, and 15 lists down the specific grounds of discrimination. However, judicial interpretation has often required the claimants to prove that discrimination is on based on only one single ground, even if they are being discriminated on multiple grounds. This by this way, they are limiting the constitution ability to respond to the compound discrimination or the structural inequalities that are present. Historically, Indian courts have read Article 15 restrictively, focusing on only one ground as the point of discrimination. In cases like such as in Air India versus Nargesh Mirza, discrimination was examined through isolated categories rather than intersecting identities. This doctrinal rigidity has prevented courts from recognizing how caste, gender, disability, and socioeconomic status interact to produce deeper forms of exclusion. But in recent years, the judiciary has shown a gradual shift. Like in the case of Nalsa, recognized transgender identity beyond binary gender norms. In case of Navtej Singh Johar, which rejected the narrow understanding of sex discrimination. Importantly, in Patan Jamalwali versus State of Andhra Pradesh, explicitly acknowledged intersectionality in context of a Dalit woman with disability. These cases mark progress but they remain exceptional in circumstances, not a systematic pattern. A comparative perspective shows similar conditions across different South Asian nations. Nepal constitution explicitly acknowledge inclusive and proportional equality, offering a greater textual space for intersectional claims. But in contrast, countries like Bangladesh, Pakistan, Sri Lanka continue to rely on formal equality models where intersectionality is largely absent in both constitutional text and judicial reasoning. So the structural gaps in equality law are that equality law often focuses on individual isolation rather than structural patterns of disadvantage. Affirmative action is treated as an exception rather than coercive mechanism. Without recognizing cumulative harm and power hierarchies, equality jurisprudence risk reinforcing the very inequality which it seeks to eliminate. So to address these gaps, the paper that we have written, the paper suggests multi-pronged reform approach. First, broader interpretation or clarification of Article 15 to allow multi-ground discrimination claims. Second, an omnibus equality act addressing both public and private discrimination. Thirdly, a harm-based judicial approach focusing on lived disadvantages rather than just a formal categories. Finally, improved data collection and institutional mechanism to capture intersectional harms. To conclude, intersectionality challenges are not just myth, equality can be achieved through uniform treatment. While Indian constitutional jurisprudence has begun acknowledging intersecting identities, meaningful equality requires moving beyond single access equality is essential for achieving substantive justice in a deeply stratified society. I am done.
Okay, so participant, like you had mentioned some of the leading judgments and also like how the course of identifying the third gender has been into the Indian constitution. So, what according to
Yes.
you, what are the challenges? Even the countries in South Asia yet to recognize those things are still prevailing. What are the challenges and how the countries should move towards those courses in South Asia?
So the first, okay, sir. So the first challenge that is firstly identifying that what kind of discrimination people are usually facing. In today's scenario also people are facing discrimination based on their gender, their caste, their race, which are interconnected, like being a girl, being transgender, being a black, being from a disabled person. That all kind of discriminations are being interconnected, and these challenges are prevalent in most of the South Asian countries. So to address these challenges, we have to identify that these kind of discrimination are actually faced by the people. Like transgender rights should be recognized. Transgender rights should be recognized that they are facing discrimination on these grounds, and cumulative approach should be that all that kind of discrimination should be addressed, not just only single sort of discrimination, like on only one ground should be addressed for all the South Asian countries, because we do not have that kind of judicial approach also and constitutional frameworks in most of the countries.
All right, we can move ahead with the next participant. Thank you.
Thank you, sir.
Abhishek Kumar can start presenting now.
Okay, ma'am. Ma'am, am I audible?
Yes, you are. Please start presenting.
Hello. Ma'am, am I audible?
Yes, you can start your presentation. You are
Hello.
audible. You are audible. You can start
Hello.
your presentation.
Hello.
You are audible. You can start
Hello.
your presentation. No.
Hello.
Abhishek, you are audible. You can start presenting.
Ma'am, am I audible, ma'am? Hello.
Yes, you are audible.
Hello.
Participant is facing some
Am
network
I
issue.
audible?
We can move ahead with the next one.
Dr. Sadanand Pandit can now present. Dr. Sadanand can present now.
Dr. Pandit, you are not visible and audible.
Hello. Am I audible, sir?
Yes, you are audible, but your presentation is not visible. It's showing Google Meet. Dr. Pandit, your presentation is not visible.
Yes, yes, I'm trying, sir. I'm trying.
If it is taking
So,
time, we can call you next. Host, we can move ahead with the next participant. Then we can call Dr. Pandit.
Okay, sir. There is some problem, sir.
Okay, okay, no
okay, sir.
issues.
Next, we can have Anugrah. You can start presenting.
Am I audible?
Yes, you
Yes, you
are.
are
Please
audible
start
and
presenting.
visible. Yeah, you can start.
Okay, thank you. Good morning, respected chair, professors, and my fellow researchers. My name is Anugrah and my paper title is Digital Constitutionalism and Democratic Legitimacy, a jurisprudential reflection on Nepal's social media ban. My paper revolves around two central questions. First, why should digital constitutionalism apply at all? And second, what does Nepal 2025 social media ban and how natural law help us to build a justified framework for digital governance? I would like all to bring their attention to a popular observation. Human society has continuously evolved from individual to communities and communities to nation state. Today, we are witnessing the same transformation again, but in a new dimension. The digital world, the people now exercise speech and communities and earn livelihood online. This represent a new constitutional movement, not created by political revolution, but by a technological disruption. Just as constitutionalism emerged to protect right in physical world, digital constitutionalism emerges to safeguard right in the virtual realm. This brings me to the key question: why constitutionalism in the digital space? Here I rely Here, I rely on social contract theory, but importantly, not on a single thinker. I use Hobbes, Rousseau, and Locke together because each explain a different aspect of the same formation process. Hobbes explains security. He described life without authority as a state of constant fear. In the digital term, this resembles cybercrime and online exploitation. On the other hand, Rousseau explains domination and equality. As societies develop, power concentrates in digital spaces. Dominant platform and voice suppress marginalized groups. Locke explained consent and liberty. He argued that authority is legitimate only when individuals agree to it. Today, digital participation is based on consent through terms of service and platform, with the expectation that fundamental freedom like expression and privacy will be protected. Together, these three paths converged on one common goal: the protection of fundamental right. This established why digital constitutionalism becomes necessary. With the foundation, I turned to Nepal. In 2025, Nepal imposed a blanket ban on major social media platform for regulatory non-compliance, but this occurred amid widespread unemployment, corruption, nepotism, and youth migration. Social media had become a crucial space for expression and economic activities and communication with familial bonds. When these platforms were banned, peaceful protests erupted. The state imposed curfew, deployed army. Dozens were killed. Eventually, political leaders resigned, including the prime minister. Moving further, what we can see here is that the government of Nepal passed an act which banned several social media platforms. They banned several social media platforms, and that ban was supported by the Supreme Court too. And if we look at from the perspective of analytical jurisprudence, it was a command of sovereign backed by sanction, but legality alone did not prevent collapse. From a natural law perspective, the ban failed substantively. It ignored people suffering that violated basic right to expression and livelihood. Throughout this paper, I revisited the debate between analytical school and natural school. This led me to the policy recommendation. At the theoretical level, digital constitutionalism must function as a hybrid model, balancing state authority, platform power, and individual right. This prevents two extreme regulatory absolutism and digital anarchy. At the practical level, I propose three safeguards. First, digital right impact assessment. This is a test before implementing digital laws. These compel government to evaluate how regulation affect expression, livelihood, and participation. Second, a graduated and participatory approach to regulation. Blanket bans should be last resort measures. Policy must be evolved civil society experts and users. This strengthens democratic legitimacy and prevents social backflash. Third, the establishment of digital constitutional authorities or specialized tribunals. These bodies would independently review executive actions, enforce proportionality, and protect fundamental rights, acting as a constitutional guardian in the digital space. Together, these measures shift digital governance from command based control to right center constitutionalism. With that, I would like to conclude my speech.
Okay, like you had talked about the digital rights right now. So one thing I want to ask you, what according to you, India, the countries like India who had recently implemented DPDPA, Digital Data Protection Act, what are the implications for the countries like India?
So basically, the thing is that any measure that government is taking, such measure must first be assessed by with the scales of digital rights. Like people who are going to access social media or any social media platform, uh, the these any act which is government is passing, those act must be just based on what kind of rights they can affect, and after such assessment then only such acts should be passed, because those acts may be legally valid, like in the case of Nepal, but they may impose some indirect implications on people, right?
All right. All right. Thank you. We will be moving ahead to Dr. Pandit now.
Thank you, sir.
Yeah, Dr. Pandit, you are not audible.
Good morning, sir.
Yes.
Am I audible?
Yes, you can. Yeah, you are audible
Sir,
and visible. You can.
actually, I am not able to share my PPT, sir.
Okay. Your screen is visible. If you can just open your screen, open your PPT now, it will be visible. Yes, it is visible. Yeah, you can.
Thank you, sir. Good morning, sir, and good morning, everyone who is joining this seminar. Now, I am going to present my PPT. My topic is traditional travel self-governance in the era of social franchise, a socio-legal perspective of civil areas of Jharkhand. So, in this topic, I would like to try to focus on the travel self-governance. As we know that local self-governance in India is a word has history. The local self-governance system has been functioning since the beginning of time.
Dr. Pandit, try to speak bit louder. Your voice is merely audible. Try to speak bit louder.
Okay, okay. The concept of local self-governance in India is as well as its history. The local
No, no, no.
self-governance
It's not audible. It's not perfectly audible, Dr. Pandit. You might be facing some issue with your earphones.
maybe, sir, but am I audible, sir?
Yes, you are audible now. Yeah, you can speak.
Oh, okay. So, the local self-governance institutions have been functioning since a long period in time in the country, as we know that, and even the tribal traditional panchayats are as old as they tribal themselves. So, traditional system of democracy in tribal areas called Munda Malki, Manji Parganait, Parha system in the Jharkhand. So, when the 74th and 74th Constitutional Amendment Act in 1972 confer constitutional status to the local government bodies, these amendments were not applicable to the scheduled areas. Therefore, the government has constituted a special committee, that is Delhi Buriasi Committee, and on the basis of that recommendation, a special law is enacted that is called the Provisions of Panchayat Extensive Scheduled Area Act, that is PESA, for the extension of the provisions of 73rd and 74th constitutional amendments. Local bodies are considered as the foundation of the governance of the country, and therefore the PESA for the first time brings the state legislature in the picture in matters concerning panchayat located in scheduled areas. So, in this way, we can understand that how the traditional panchayats work in the tribal areas. So, at the lowest level, Gram Sabha, that may be considered as the civil court, Parha system, that is the high court, and Raji Parha, that may be considered as the supreme court in tribal and scheduled areas. Particularly, I'm talking about the Jharkhand. While I was preparing this research paper at that time, I have reviewed so many uh, earlier work done on this subject, and I have also gone through so many case laws. My research questions are these: what constitute the core rights in the self-governance model for the tribal people in India? What are the various hindrances faced by the several government in governing the tribal people and tribal land? What which self-governing system, whether provided under PESA or customary panchayat, would be more advantageous to the tribal people? These are the research questions I have covered in this research paper. Aims and objective: to make a critical legal study of self-governance system of tribal people provided under 5th schedule of the Constitution, to explore the working condition of local governing system prevalent among tribal people of Jharkhand, and we also focus the governance power and application of it. And while I have also I have done a comparative study of the traditional governing system versus a state structure panchayat raj system, because there is a special law that is called Jharkhand Panchayat Raj Act 2001 that is applicable to the general areas, and the uh, PESA applies to the scheduled areas. These are my methodology while I was preparing the research paper. Sources of data collection, my profile area from where I have conducted my research, the major findings. The tribal expects a lot of things from the ability of law and the willingness of the administration to protect their interest. Gram Sabha exists, but it is not well equipped in terms of financial structure or decision-making power to ensure Gram Swaraj. Recently, PESA rules are framed in Jharkhand. It means that the law PESA is enacted in 1996, but the rules are just framed by the state government of Jharkhand, and it came into effect on 2nd January 2025, 26. Sorry. The protecting the land and forest right of the tribal community is equivalent to protecting their livelihood, life, and liberty. Generally, multi-battery is given to for level acquisition, but no strict legal principle for providing land for land. And in PESA, there is a provisions for the upliftment from 5th schedule to 6th schedule administration, but the government is not taking any action in this regard. The governor has a lot of discretionary power in 5th schedule. He may critically utilize it in fullest potential, but it has not been seen in case of scheduled areas. Tribal people have fear of identity loss and the perception of becoming minority due to the effect of LPG concept. Less proactive role of the government to implement the provisions of the 5th schedule and other laws. Major responsibility for the development of scheduled areas and scheduled tribes has been placed on the union government. A suggestion.
Participant, you had exceeded the time. You can conclude with your suggestion.
Okay, sir. Just suggestion and recommendation. No state has framed the funds, function, and functionaries in the all 29 identified subjects that is provided under Schedule 11. Even any company is given travel land for establishment in such condition, company should grant 50 to 20% shareholder to the tribal people. The last conclusion would be that a strong rehabilitation and resettlement package should be added for the affected and displaced tribal people, because tribal people feel that they are not given adequate uh, power to take part into decision making. So their lands and their resources are being taken by the corporate houses. In spite of that, they are not being given the adequate representation in decision making. That's all in my side.
Okay, so you had mentioned that due to the less proactive mechanism, the various progress-related activities in those scheduled areas are getting hampered. So, what are
Yes,
the solutions towards this?
the solution lies with these provisions of the Constitution that the Article 244, Clause 1 and Schedule 5 talks about the administration and welfare of the scheduled areas and tribal people. Though they have been given so many rights, and on the basis of that, there are certain special laws. In spite of that, the government is not taking any action for the welfare and development of the scheduled areas and tribal people. They feel cheated, because some scholars has represented and expressed their view that fifth schedule is the constitution within constitution. In spite of that, the provisions of the fifth schedule are not being implemented. That's why tribal groups think that they are they are being cheated. Though lollipop is shown, but they are not entitled to have it.
All right, Dr. Pandit, thank you for your presentation.
Okay, thank you.
Yeah, we can move ahead with the next participant.
Everyone can present now.
Yes, participants, start your presentation. Start your presentation. Participants, start your presentation.
Abhishek, please start presenting.
Start your presentation, participant.
Am I audible,
We
ma'am?
can have.
Hello.
Okay, yeah, you are audible. Please start presenting.
Hello. Ma'am, am I audible?
Yes, you are audible. Please start
Ma'am,
presenting.
can I Start. Yes, participants, start your presentation. Okay, sir. Start your presentation. Participants, start your presentation. Hello, am I audible?
You
Yes,
are
Abhishek, you are
perfectly
audible.
I
audible.
can't hear you, ma'am or sir. I can't hear you.
Host, I will suggest you
Sorry.
to write him instruction in your chat box, and we'll be moving ahead with the next participant.
Can you give me just 1 second? Just give me 1 second. 1 second. I can't hear you. I am not able to hear you, but I am starting my presentation. If you are, because I am saying ma'am is writing that I am audible, so I am starting my presentation, sir. So, good morning, one and all present. My name is Abhishek Kumar. I am currently pursuing my LLM from Gujarat National Law University. My topic is the rise of judicial activism or judicial overreach, a comparative analysis of public interest litigation in India and South Africa. My paper tackles a question that haunts every modern democracy. When does a judge stop being guardian of the law and start becoming a legislator? Today I present a comparative analysis of public interest litigation in two giants of global south, India and South Africa. Both nations share a history of deep struggle and equality, yet they have taken two different judicial paths to solve it. My inquiry is simple. Does the rise of PIL represents necessary judicial activism enforcing constitutional values, or we have crossed the dangerous line into judicial overreach, stepping into the domain of the executive? So let's now start with the context. Courts have become the last resort for the marginalized. In India, PIL was a judicial invention of the late 90s, 70s, and 80s. It was a creative tool forged by judges because the legislature was silent on the needs of the poor. In South Africa, however, PIL was invented, it was mandated. The post apartheid constitution of 1994 explicitly enshrined social economic rights, housing, healthcare, education, and commanded the courts to enforce them. This leads to the central tension. In India, the court carved out this space itself. In South Africa, the constitution carved it out for them. Let's now see the India's journey, how India has progressed it. It began with the revolution in the procedure. In S.P. Gupta, the Supreme Court famously declared that any public-spirited citizen could knock on the doors of thereby transforming it into a people's court. But let's talk about why this matters. Take the landmark judgment of Vishakha versus State of Rajasthan. This wasn't just a legal dispute, it was a tragedy where a social worker was gang raped and there was no law in place to protect the woman in the workplace. Parliament was silent, the executive was silent, so the Supreme Court stepped in. They didn't just adjudicate, they drafted the Vishaka guidelines, effectively writing the law that was bound on the entire country until the parliament enacted the new law. While celebrated for women's rights, this is a textbook definition of this debate. The court admitted it was legislating because of a vacuum, but critics asked, is it his court's job to write a law or simply interpret it? South Africa's journey, the reasonableness test. Now contrast this with the South Africa. The constitution guarantees the constitution guarantees housing, health, but to the courts adopted a unique strategy called reasonableness review. Unlike India, where the courts might issue detailed guidelines, the South Africa Constitutional Court rarely dictates the details of a policy. Instead, it engages in a dialogue. They ask the government, is your plan reasonable? If the answer is no, they send the government back to the drawing board. They don't want to run the country. They just want to ensure that the government is doing their job. Now, let us see some comparative landmarks. In South Africa, the Groot Bomb case, a community of squatters had been evicted and left homeless in the rain. They sued for their right of housing. The court ruled that the government housing policy was unconstitutional because it prioritized long term planning over immediate relief for further disparate. And this is the crucial difference. The court did not order the state to build 1,000 houses the next day. It ordered the state to devise a reasonable program that included emergency relief. Compare that to the treatment action case regarding HIV/AIDS. The court was more aggressive. The government refused to distribute neoprene to pregnant mothers. The court rejected the government's excuses about limited resources and ordered a national-wide rollout of the drug. Here we see the South Africa acting like an Indian court, issuing a mandatory order because their lives were stake. But if you want to see the aggressive approach taken its to logical conclusion, we have to look at India. In the Vishakha case, Indian Supreme Court did something South African courts rarely do. They acted as a temporary legislature, finding a complete vacuum in the law regarding sexual harassment. The court drafted its own guidelines and ordered them to be treated as a law. Now let us see the modern friction. This is just the history. The debate is alive till now. In the most post-COVID era in India, during the 2020 lockdown, the Supreme Court took the suo motu cognizance of the migrant labor crisis, directing government to provide food, transport. While humane, it raised the question that it is the court's job to managing disaster relief. Conversely, we are seeking a pushback. This court is becoming more stricter, dismissing frivolous PILs, imposing cost to abuse the process of the system. Meanwhile, in South Africa, last year, in 2025 January, the Pretoria High Court made a stunning ruling regarding the social relief distress grant. The court held that it is a temporary grant had become a permanent right and ordered the government to increase the budget. Think about the implications. A court telling the government to increase the welfare budget. It challenges the very core fiscal of the fiscal sovereignty. Yet the court justified it on the grounds of human dignity. Why does the Indian court feel comfortable writing laws while South African courts prefer to ask government? It all comes down to the constitutional design. In India, because the separation of power is implicit, the court used the basic structure to become a bold guardian. We call this corrective activism. The court sees vacuum and fills it. Think of it as a bypass surgery of a clogged executive. In contrast, South Africa, there is explicit separation of powers. Judges have a clear mandate to protect the rights like housing, health, but they are also constitutionally bound to consider available resources. They don't want to command, they want to dialogue. While India leads towards corrective activism, South Africa leads towards a transformative adjudication, where the court acts as a catalyst for a long time social change rather than an immediate administrative manager. So, it was an activism or overreach. My research suggests that the perception of overreach depends entirely on constitutional design. India's implicit separation of powers becomes bold and sometimes unrestrained guardians. South Africa's explicit separation of power forced judges to become more
Participant,
restrained,
you can
justifying
conclude.
their actions through reasonableness and available resources.
Participant, you
Ultimately,
have
my
exceeded
paper
the time.
argues that in societies that is deeply scarred by the deep inequality, like India and South Africa, judicial passivity is not an option. What we are seeing is a transformative adjudication. And at last, the future of PIL lies not in the judges running the government, but judges forcing the government to answer the constitution. That would be my time. Thank you so much.
Okay, since you would be not hearing our questions, so we'll be moving ahead with the next.
Okay. So next we can have Dr. Nikhil to present.
Yes, Dr. Nikhil, you can unmute yourself. You are not audible. You are not audible,
No, sir, you
Dr.
are not
Nikhil.
audible.
Kindly unmute and speak. No, you are not audible. You're facing issue with your mic.
For the time being, we can have Mayank to present if you allow, sir.
Dr. Nikhil, we'd be calling you immediately after one participant. Kindly just make your technicalities ready if you are having any technical issue. You are not audible. Yes, we can go with Mayank.
Okay, Mayank can present now. Mayank, are you there? Mayank?
Then we can
Then
move
we
ahead,
can have
Miss.
Shivani Pahuja.
Yes. Go ahead with Shivani.
Good afternoon, sir. Good afternoon, ma'am. Am I audible?
Yes, you are audible and visible. Kindly share your presentation.
Sure.
All the participants, those who are present here, kindly make your presentation loaded. Your screen is visible, but your presentation is not.
Is it visible now?
No, it is StreamYard platform is visible here.
So I have opened my presentation.
You might have not given permission to your entire screen. It is just one of the.
While I just clicked on present and then shared screen. After that, entire screen, right?
Yes, entire screen.
Is it visible now?
Yes, it
Yes, it
is.
is.
Please start presenting.
You can start. Yes.
Okay, so good morning. My name is Shivani Pauja, and my topic for the presentation is role of judiciary in bringing electoral reforms in India. So, as we know that the cornerstone of electoral democracy is free and fair elections, which ensure the presence of political competition and constitutional governance. India's constitution serves as the foundation for conducting these elections, but persistent challenges such as criminalization of politics, misuse of state machinery, identity based mobilization, and declining institutional trust have raised concerns about electoral integrity. This paper examines how judicial intervention has shaped electoral system design, political equality, and institutional accountability in India. The primary research question guiding this study is how has judicial intervention shaped electoral system design and institutional accountability. This paper is based on a doctrinal and a qualitative methodology relying on statutes, available literature, landmark judicial decisions, as well as the constitutional provisions. The evolution of judicial oversight in electoral governance has been traced through the cases of Indira Gandhi versus Raj Narayan, ADR and PUCL versus Union of India, Lily Thomas, as well as some of the recent cases, for example, Anup Baranwal case, as well as ADR versus Union of India. So the some of the key judicial contributions for elections or electoral democracy has been that courts have functioned as critical guardians of democratic legitimacy, filling the legislative gaps through landmark decisions. So, one of the major problems that India faces is that where electoral reforms are needed, there are various legislative gaps, and the legislature does not actually want to work in that area because it is there for their own benefit. That is why the judiciary has to intervene in these spaces and fill in the gaps and maintain equality and electoral integrity in India. Judiciary has also preserved the constitutional principles of fair elections and curbed criminalization of politics. And Supreme Court and the High Courts have strengthened the independence of election management bodies as well as the voter rights in the country. So the evolution of judicial oversight, as I already discussed, has been tracked through various cases in India, and these decisions demonstrate how the courts have worked on areas of voter manipulation, erosion of institutional morality, as well as the emerging threats of money power. So key judicial contributions have been regarding the voter rights. The voter rights have been re-christened as a fundamental right, making disclosure of candidate antecedents compulsory. There was also nota was included in the elections. It broadened the right to reject for the candidates. Right to elect also includes the right to reject, and this was upheld in the case of PUCL versus Union of India. Next is that there should be financial transparency in elections, which added to the vitiating role of money in electoral democracy through stricter implementation. Next is the Supreme Court and the High Courts helped in strengthening the Election Commission's independence and appointment process, because there were too many executives that were seen in the process of electing Election Commission's members. So, if the Election Commission itself is not an independent body, it would lead to more of the executive power in elections. That means that whoever is in power in the government can try to adjust the election commission in its own way. Therefore, in the case of Anup Baranwal, it was said that the role of the executives should be decreased, and new members were made. For
Participant, you
example,
had
the Chief
exceeded the
Justice of
time. Participant, you had exceeded the time. Kindly conclude with your suggestions.
Sure. So, my conclusion is that the fundamental tenet of democracy is the right to vote in free and fair elections, which is also enshrined in the Indian Constitution as well as the preamble of the country. While the system is not risk-free, its goal remains excellent. The Election Commission's independence is equally crucial as the judiciary's, since both dispense justice with fear or favor. Current legislation remains insufficient to counter the threats posed by corrupt electoral practices, requiring nationwide voter education campaigns and additional measures. Despite Article 329 limiting judicial involvement in electoral matters, the Supreme Court has consistently fulfilled its constitutional mandate, upholding constitutionalism and protecting citizens' right while keeping other branches within constitutional bounds.
Okay, all right. I'm not
Thank you
having any
so much.
question for you. Okay, thank you.
Thank you.
We can move ahead with the next participant. Yeah, Dr. Nikhil.
Sir, you are not audible.
Dr. Nikhil. Dr. Nikhil, try to rejoin, or like from different devices, or from this device only try to rejoin. Your voice is not reachable to us. Till the time being, try to rejoin Dr. Nikhil. We'll be calling you just after 1 2 participants. Yes, host, we would be moving ahead with the next participant.
The next participant would be Mayank A. Chandra. Are you there? Please start presenting.
No, Mayank is not reachable.
Then we can have Amrita Tiwari to present.
Is it visible now?
Yes, it is. Please start presenting.
So, greetings to the respected chair. Today, I will be presenting on the topic perception, awareness, and practice of freedom of speech under Article 19(1)(a) among media houses. So, we all know that Article 19(1)(a) forms the foundation of Indian democracy and enables free exchange of ideas. The media, often referred to as fourth pillar of democracy, plays a crucial role in informing citizens and ensuring accountability. But in recent times, media freedom has been affected by political interference, corporate control, and digital regulation. So this paper examines whether what media institution perceive and exercise this constitutional right in practice. So the objectives are to examine the constitutional basis of freedom of speech under Article 19(1)(a) and to analyze how courts have interpreted it and what are the perception and awareness of media institution regarding this. And so, for this, the study follows a doctrinal and theoretical research methodology, and it is based on analysis of constitutional provisions, landmark judgments, and secondary sources. Uh, then, then comes the constitutional and theoretical basis. So we all know that Article 19(1)(a) it guarantees freedom of speech and expression to all its citizens, while Article 19(2) it imposes reasonable restriction on the ground of public order, morality, and national security. So, from a theoretical perspective, freedom of speech is essential for discovering truth, encouraging democratic participation, and preventing abuse of power. Now, the doctrinal evolution of this. So, I'll be covering several cases. Starting with the Ramesh Thapar versus State of Madras, we all know that it was the first case regarding this media freedom. So, Supreme Court recognized freedom of press as an integral part in this case. Then, Bennett Coleman versus Union of India. So, in this case, the court held that indirect restrictions such as control over newsprints violate press freedom. And similarly, in Indian Express case also, economic measures were held incapable of restricting media freedoms. So these judgments established that press freedom is constitutional right. So, despite this constitutional protection, media institutions operate within political, economic, and regulatory constraints. But bodies such as Press Council of India aims to promote ethical journalism and protect press freedom. But their powers are largely advisory. As a result, awareness and confidence is very necessary. The practical challenges. The practical challenges in this are the practical challenges being political pressure, corporate ownership, market dependence, and digital regulations. So, political pressure is often exerted through defamation laws, regulatory mechanisms, and selective government advertising. And corporate ownership and market dependence, it leads to self censorship because of influence of editorial decisions. Uh, then comes media practitioners' perception. So another important issue is the limited constitutional awareness among media practitioners. Media education tend to focus more on technical skills than legal literacy. Regional and vernacular journalists are more vulnerable due to lack of institutional support. Moreover, sensationalism and trial by media have weakened public trust and indirectly affected the credibility of press freedom. So, in conclusion, I just want to say that Article 19(1)(a) remains central to democratic governance, and judiciary has consistently upheld press freedom. But, however, political interference, market forces, and digital regulation continues to limit effective exercise. So, true freedom of speech requires not only in constitutional protection but also ethical responsibility and institutional awareness. So, strengthening constitutional literacy, promoting ethical self regulation, and reducing indirect interference are essential. Thank you.
Okay, participant, you had mentioned all the aspect, but one aspect you had left out. That's on the recent amendment of the criminal laws. BNS is having section 152. It is the sedition law. So, in one hand, the government is coming up that we had completely remitted or omitted the seditious laws. Like our honorable home minister comes into the dais and gives the speech that sedition is no more a law in India. But in other hand, we are having a provisions too wide to include everything just within the proclamation of that anything goes against the government, it's illegal or can be completely traced with the enforcement. So, like, I would like you to come up with the assessment of section 152 of BNS along with the right to freedom of speech and expression.
So,
That's my suggestion. It's not my question. That's my suggestions to include it in your
okay, sir.
revised version of your manuscript in your research.
Okay, sir. Okay, I'll include it.
All right. Yeah.
Thank you, sir.
So next we can have Tejas to present.
Hello there. Is my screen visible? Is my screen visible?
Yes, your screen is visible. You can start.
All right, so good afternoon. Today I'll be presenting my research on AI governance in the public administration, which will focus on how artificial intelligence can improve the public service delivery while we are still protecting the constitutional rights, transparency, and the democratic accountability in the Southern Asia, particularly to India. So let's move on to the introductory part. You see, artificial intelligence is rapidly transforming across South Asia. AI systems are now being used in like welfare delivery, digital identity, education, healthcare, and urban governance to improve the efficiency, accuracy, and the decision-making part. So, however, these technological benefits also create a serious constitutional concerns, which includes lack of transparency and risk in the due process or threat to privacy and potential discrimination. So therefore, the key challenge is in balancing the technological efficiency with the democratic and constitutional safeguards. Let's move on to the research methodology. Now, this research asks a central question. How can AI-based decision-making in the public administration be structured to uphold equality, fairness, and accountability in the South Asian democracies? To answer this, we use doctrinal legal analysis and then case studies on AI, followed by the comparative analysis of Bangladesh, Sri Lanka, and Nepal. So the overall goal over here is to reconcile the administrative efficiency with constitutional guarantees. So if we were to look at the theoretical framework, on my very left, we have to understand first these two key theories. Firstly, the administrative constitutionalism, followed by secondly, the digital constitutionalism. What administrative constitutional does is which requires executive action to follow the rule of law, equality, and accountability. Followed by the digital constitutionalism is what which extends privacy, due process, and transparency protection into the digital and the algorithmic sphere. So together, these frameworks they establish that AI used by states must remain transparent. It should be explainable and it should be right respecting. So let's move on to the constitutional foundation in India. As we all know about Article 14, 21, and 38 and 41. So Article 14 talks about, guarantees equality and prohibits arbitrary state action, followed by Article 21, which protects life, liberty, privacy, and procedural fairness, which was as affirmed by Swami case about the other case. And then followed by Article 38 and 41, which imposes, welfare obligations to ensure that social justice and public assistance go hand to hand. And now, therefore, AI-driven governance must remain non-discriminatory is what we are trying to state. So, as I stated earlier, it should be privacy protected as well. So let's talk about AI in public administration. Now, these are the key sectors. Firstly, we'll talk about the welfare system. So AI improves targeting and reduces fraud, but biometric failures or data errors may exclude these vulnerable groups. Or let's talk about digital identity like Aadhaar. So AI enables what do we call seamless service delivery, but it does raise like certain concerns of profiling and privacy risks. And then in education healthcare, AI supposedly it promotes personalized learning and disease prediction. Yet this issues a bias in the data protection realm. And then in smart cities, for example, you can take Bangalore. So they have AI to improve traffic. So you see all the signals which is controlled through AI. So it measures the distance and then it predicts the timing. But this may reduce in transparency and human discretion. So thus, strong safeguards are essential to ensure that fairness and inclusion is present. Let's talk about transparency and accountability. A major concern with AI governance is something we call as the black box. So black box problem is where the algorithmic decision lack clear reasoning. So Indian administrative law requires decision affecting rights to be reasoned, transparent, and reviewable. So if citizens must have a right to explanation, access to remedies, and effective grievance redressal, these institutional safeguards like audit trails or human supervision is highly required. So if we wait to give everything to AI, that will in turn cause problems to us. We don't know how it arrived to a particular conclusion or where the data was taken from. That's what I'm trying to state over here. Let's talk about the comparative South Asian governance. For example, across South Asia, countries are developing AI, governance differently. For example, if you take about Bangladesh, they emphasize that ethical and human-centered AI should be present. And in Sri Lanka, they focus more of reasonable regulatory framework. And then in Nepal, they prioritize institutional regulations and data protections primarily. So these variations show that the importance of context-specific governance, which this focus on the specific value, while also highlighting the need for regional cooperation. So with this, there does come risk and policy recommendations. So let's talk about the risk first. You see, the unchecked AI in the governance can lead to extensive outreach and algorithmic bias, which could cause exclusion, obviously, and then which could also ultimately, the main concern is it would reduce transparency and accountability. So to address this, this paper proposes that a right-based AI regulatory framework, mandatory algorithmic assessment, and then a legal right to explanation. So this strong grievance redressal and human oversight should be present, which could ultimately improve the data governance part. So with this, I would like to conclude by stating that you see AI has an immense potential to improve efficiency, inclusivity, and responsive to the public governance. But without transparency, which is a key element, so there should be a democratic oversight. So it may also deepen the inequality or opacity in this sense. Therefore, the future of AI public administration must be right-based, accountable, and constitutionally grounded. Is how I'd like to conclude. Thank you.
Okay, participants, since you belong from the practicing category, like you are already a professionals. So what, according to your perspective, AI is shaping for the governance to the courtroom? For last 2-3 years, Supreme Court has been using artificial intelligence for even dictating the judgments into the transcripting. So there are accountability as well as there are errors within the AI system. So how you perceive it?
So let's talk about, for example, if we were to take in that case, we all know what we have. We should have an electronic digital record, like the 63B certificate. So the thing is, we always look at the conclusion area, as I stated. We do not look how did we arrive to that particular conclusion, even though the courts are using AI and all of those stuff. As you well stated, there are problems, there are inconsistencies. So what I'm trying to state is that if there were any AI system which is to be used in our government, they should state it out in public. What are the type of AI system they're using? Is it different? What are the safeguard checks? And there should be a well laid out rule for that. Is what I trying to contend.
Okay, have you included the recent AI report by the Niti Aayog here?
I don't believe so, sir.
Okay, try to include in it and try to have a study, because two reports recently has been included. One report from the United Nations Internet Governance Forum. Another report has been provided by the Niti Aayog's AI report in the month of July, if I am not wrong. And also India presently would be having a summit, AI summit, on the 17th of this month, India AI summit of
Yes.
2026. Yeah, so all these things would be taken into consideration in that summit. I will really recommend you to have the look into the summit report after its publication in the last week of February. Whatever discussions and deliberation would be held in that summit would be included there. So looking forward to your paper, specifically having the concerns of the artificial intelligence towards its governing policy. We need a governance policy, that how the countries like in South Asia can come up with those challenges, practical challenges, and if we overlook it, it would be create a chaos to our governance in the coming
Definitely,
future.
sir.
Yes. All right. Thank you.
Thank you.
So now we can have Sana to present. Sana, are you there?
Yes, participants, you are not audible. No, you are not audible,
Sana,
participant.
Sana, please unmute yourself.
Sana and Rajan. Rajan, you are also not audible. Mr. Dahiya.
Uh,
Okay, yes. Participants, we are not able to hear you. Are not audible. No, we are unable to hear you.
Can you hear me?
Yes, we can hear you, but we are unable to hear Mr. Dahiya.
Hello?
Yes, you are audible. Miss Alvi, you are audible. You can start if you are ready to go with. Host will be starting with the next participant. So they are facing network issue.
okay, so the next participant we can have Dr. Nikhil.
Yes, Dr. Nikhil, are you like? Can you speak now?
So you are
Speak.
not audible.
Many participants are having this issue with the audibility. Okay, we can go with Vijay Lakshmi.
Yes. Vijay Lakshmi, you can present now.
Uh, okay. Am I audible and visible to everyone?
Yes, you can start.
Okay. Just give me just one moment, sir. I I need to share the screen.
Your presentation is already visible, madam. You can start.
Okay, sir. I thought I had to share the screen. I'm really sorry.
Your slides
Uh,
are already visible. You can just keep your slide moving. Yeah.
okay. Good morning, everyone. This is Vijayalakshmi, and I'm here to present my paper on judicial appointment mechanism and independence of judiciary in South Asian democracy. So, the question, who guards the guardians? This question is the heartbeat of every constitutional democracy. We often say that judiciary is the central pillar of the state, but as Chief Justice John Marshall once famously noted, it is emphatically the province and the duty of the judicial department to say what the law is. However, for a judge to say what the law is without fear or favor, they must be shielded from those who write the law. Uh, so today we examine a fascinating tug of war in South Asia. In India, Pakistan, and Bangladesh, we see a shared colonial history diverging into three distinct experiments in judicial autonomy. The dilemma is simple yet profound. If politicians choose judges, the court becomes a political tool. If judges choose themselves, the court becomes an ivory tower and an echo chamber. So, in this the after going through all the democracies across the three countries, we have come up with three models over here that dominates judicial appointments. First, the executive led model wherein the executive branches appoints makes the appointment. Judiciary led models where the judicial fraternity appoints the judges from themselves, and a hybrid model which is often seen across different democracies, wherein a commission is established and we see an overlap of both the members, both the organs such as executive and judiciary in there. Now, when we talk about the evolution of judicial appointments in the three democracies that I'm going to discuss, India, Pakistan, and Bangladesh. So in India, we see like India perhaps represents the most radical shift in the judicial supremacy in the world. So originally the system was executive led, but through the landmark three judges cases in the Supreme Court effectively rewrote the constitutional script. They transformed consultation into concurrence, thereby giving birth to the collegium system, a model where judges appoint judges. However, an attempt was made in the year 2014 by the government to break free from this monopoly with the conception of National Judicial Appointment Commission. However, the court struck it down, deeming it unconstitutional, invoking the basic structure doctrine to protect its independence. So, while India enjoys high independence, it faces a transparency deficit. It has successfully avoided executive judges, but the critics argue that it has created judicial emperors. Now, if we were to talk about Pakistan, so Pakistan, if India is a story of consolidation, Pakistan's is a story of oscillation. Its history is a rhythmic swing between aggressive judicial activism and sharp executive pushback. For years, the Al Jihad Trust case ensured judicial primacy, but the tide has turned again. With the recent 26th Amendment, Pakistan has moved to a hybrid legislation model. No longer is the senior most judges automatically the Chief Justice, and now a special parliamentary committee selects the judges from the panel. This move aims to curb the judicial overreach, but it risks significant turning the courtroom into a political theater. Pakistan exists in what we call a zone of constitutional uncertainty, struggling to find a middle ground, but does not sacrifice, which does not sacrifice the bench to the ballot box. Now, when we talk now, coming to the Bangladesh, in contrast to both the democracy, Bangladesh has historically been the executive stronghold. By the Article 1920, by the under Article 95 of the Constitution of Bangladesh, the president and by extension the prime minister held the keys to the courtroom. This led to a system where political loyalty often outweighs legal merit. However, we are witnessing a historic pivot. The 2025 Supreme Judicial Appointment Council Ordinance marks the transition to a hybrid model. By creating a seven-member council by the Chief Justice to vet candidates, Bangladesh is attempting to transform judiciary from a government department to an independent branch. It is the rising reformer seeking to ensure that, in the words of the paper, the robe is not a reward for political loyalty. Now, to conclude, what we are seeing over here, our comparative study reveals that no single model is a panic or solution for the situation, the conundrum that we are facing. Wherein India's model, which is a judicial-led model, lacks accountability. On the other hand, Bangladesh model lacks independence, and Pakistan's model, which represents a hybrid system, it lacks stability. What we propose in our paper is a path forward, which is in two situations. First, if we were to adopt a judicial, let's say, collegium-based system, we need a certain fixed guideline that would ensure transparency and accountability, which is the most fundamental essentials of a democratic society. If we are to adopt a hybrid system, we must make sure that there is a set guidelines so as to who will make the cut for the commission. The commission is free from the influence, and the commission should not only consist of the members from judicial and executive fraternity, but members from all walks of the society, all the major stakeholders of the society. Where the bench provides expertise, the executive would provide democratic legitimacy, and the bar would provide transparency. We must remember that judicial independence is not a privilege for the judges, but it is a right for the citizens. Without a balanced appointment system, constitutional guarantee are nothing, and as rightly said by James Madison, they becomes reduced to apartment barriers. We do not need executive judges or judicial emperors. We need transparent, merit-based system that honors the law above the lawmaker. Thank you so much.
Okay, so participant, my only question to you, what are the countries where independence of the judicial system is being followed? And also, have you looked into the report of the Indian government where like the government is coming up with the committee report for the appointment of the Judges Act, which has been suggested?
Sir, I'm really sorry, but can you repeat the question? Your voice was slightly breaking up.
Okay, my question is firstly, what are the countries where the independence of the judges are being followed in a very separate way, like it is not related to any of the system of governance? And second question, have you followed the committee report of the commission which suggested the reform of the appointment in the judicial system in India?
So to answer your first question as to what are the countries where we see absolute judicial independence, uh, well, judicial independence, as in my experience and in my understanding for what I have read so far, is nowhere to be found in absolute sense as a straight jacket formula. There is no watertight separation we see in terms of separation of judiciary from any other organ of the democratic society. In all the countries, be it USA, we see influence of executive there. We see other South Asian democracy, we see the influence from some other society, from other system as well. So to answer your question, I have not come across like so far where I see a watertight separation of the judicial organ from the rest of the society, from the rest of the organ. Now, to answer the second question, uh, I would request. I'm not aware of the appointment, the commission that you're talking about. I'm really sorry. I would look into it and get like add it to my paper if there is. I'm
Yeah,
not aware of
definitely.
that.
Looked into it because when the government of India suggested that a judicial reform is required in the appointment of judiciary, they had submitted like number of pages report on it and the reasons for this. So you have to also look into those reasons and limitations. What are the independence of judiciary and how like those limitations can come up with the more separation of judiciary mechanism. So ultimately our goal is to come up with the idea that how a judiciary should be separated, not connected to any of the governance, right?
Okay. Sure, sir. I would definitely look into it and would incorporate the same in the paper as well.
Okay, all right, yeah, we'll be moving ahead with the next.
Thank you so much, sir.
Next, we can have Mr. Nikhil to present.
Yes, Dr. Nikhil.
Otherwise, we can have Sana to present.
Okay, yes, participant, you can start with your presentation.
Okay. Actually, I was waiting for my co-participant to appear on the
So is
horizon.
my
Yeah,
screen
Sana is
visible?
there. Yeah, you
Yes,
are
yes,
audible also.
yes. Start
You
start with your
start.
presentation.
Good afternoon, respected chair. I'm Sana, a third year law student, and presenting a paper titled Am I a Terrorist? The Unanswerable Question in a World Where States Hold the Pen, co-authored with Mr. Rajan Daya, who's serving as a deputy legal advisor with the Central Bureau of Investigation and brings over 2 decades of experience in prosecuting complex criminal and terrorism related cases, including the 2008 Assam bomb blast matter. This paper brings together both academic analysis and prosecutorial experience to examine a critical question for the modern democracies of South Asia, which is that who has the power to label someone as a terrorist and what constitutional limits must restrain that power. Over to Mr. Rajan Daya. Thank you.
Okay. Thank you, Sana. Well, I may start with because the all over worldwide, the definition terrorism has not been in the precise form. So a person may be terrorist for someone, but for other person he may be a freedom fighter as well. And there has been global conflicts where we have noticed this kind of scenario, like if somebody is fighting for some self determination or autonomy, then he may go for the struggle, but struggle may not be seen as by system as a means to political freedom, but an act of terrorism. So there has been some global example, like well, India has suffered from terrorism since long, and in our neighborhood also, Sri Lanka and Tamilian have been fighting for their rights. Well, there has been best case of Bangladesh, where Bangladesh was created out of Pakistan, and but the problem was that on one side, Punjab, West Punjab was literally um, terrorizing the people of the Bengal, who were speaking Bengali language. And similarly, even other countries in Pakistan itself is facing this problem in Balochistan. So, but here, how a person can be blind, if you see the historically point of view, when British were ruling India, there have been individual example as well all over the world, like Bhagat Singh. On one side, we call him revolutionary, but for British regime, it was a terrorist. And similarly, on the other line, you see in South Africa, Nelson Mandela. And for the South African regime, though he was fighting for the freedom of his country, but he was taken into other perception. So now, what we have to see whether the state can itself commit the act of terrorism against its own citizen. Because when we need to control, there had been dissent, have been autonomy movements, and students also fighting for their rights. But sometimes states go also beyond their reach, and they act because act of this judicial and this, you can say, fake encounters and custodial deaths sometimes take place, whether these can be termed also act of terrorism against its own citizen. And though so far as what are the governing laws so far as India is concerned, There has been a POTA which remained for long, then it was abolished. But against when POTA was done away with, then Unite Unlawful Prevention Activity Act came, and similarly there have been act like Makoka, like you can say that this is against organized crime. But of course, terrorism activity is also an organized crime. It can be committed by individual, it can be committed by the groups. And how this law, because there's responsibility of all the organs of the government. You see, it is a legislature job to make an act or a policy, and the executive implements this. And then there's a other part of the state, third organ, that's a judicial scrutiny, and courts have to see that with law which have been implemented, they have to be applied to in a right perspective, because there has been on one side right of victims, there has been right of the person who have been suffered by the act of terrorism, and that person who is facing trial now accused of terrorism, he has to have also some judicial safeguards, so that innocent person may not be termed a terrorist and may be convicted without following the proper judicial safeguards. He has also right of a fair trial. Now, I will reflect little bit on my experience of where CBI is concerned, because CBI has been involved apart from corruption cases in these kind of cases, and though I was not part of Mumbai Mamla's case, but it's still running. People have the main perpetrators absconded from the country, and so many people have been convicted, but trial is still continuing. It is not dead yet. On the other side, you see this Kazab case and Jamal Kazab case, and he was seen on the camera doing committing acts of killing people. So, but still he had to go, that his trial took place, and evidence were produced against him, though trial was swift. And on the other side, yes, I was associated with Assam Bamla's case. Those bombings took place in 2008, but till the time the special court was constituted in 2018 January, till the only 85 witnesses were examined, and all the accused were languished in jail except one person who was head of the NDFB, National Democratic Bodoland Front, Ranjan Damiari. But after the special court was constituted, trial concluded within a year, and it led it to exemplary conviction of all the accused person except one or two, and that conviction has been upheld by the Honorable High Court, and the matter must be now in Supreme Court. I am not no more part of the process. And so, see, what I want to say is that there has to be balance, because an act of terrorism, some act of fighting for my own freedom and self-determination, and there has been issues involving different communities, like Assam Bamla's case was itself. Bodos were going for their separate identity. They are tribal people in Assam. Similarly, movement for whole of Assam was going on in the name of Alpha. There was an organization. But what we have to see is, we have to balance the things. We have to, like on the one side, their rights of victim, people have died, because main purpose, then we have to see what is the purpose of terrorism and what are the means. Through purpose may be good. They must be fighting for some individuality, some rights, some freedom, but the means are very severe sometimes on the other side, on the general public. And there had been act of hijacking and bombing and shooting people, innocent people. So what has to be done? We have to balance this rights, and even when law is very strict, because confession before police officer are admissible so far as these laws are concerned, and there has to be a sunset clause also regarding these acts. And if the law is strict, if there are punishment sentence over is concerned is very severe, so there has to be strict liability. We have to implement the law in the right perspective. So this is how I think this paper would like to present itself. And thank you very much. And if there are questions, please I think
Okay,
I'm
yes.
open to the questions.
Yes,
Sir.
Mr. Rajan, first at all, after several years of experience and your several years of understanding into the Central Bureau, you had been projecting your way, the how the terrorist has been coming up, and how you just very well mentioned that we have to look into the purpose of their activity, like what are the purpose, why they did those activity in order to go into the root cause of the terrorism. Now, my first and foremost question to you, well, we determine the cases. Like I had been into various panels throughout the country, not only in India but in South Asia. So when we looked into in some of the forums, also as a chair, when we looked into the cases as the experts in those field, we generally get some of the nuances that even when the cases went into the court, and also like the court looks into, but the court doesn't consider the backgrounds, it's only looks into the damages. So what you feel, whether should we look, if as you well mentioned, if we looked into the backgrounds, then the proportionality of the damages to the backgrounds of the harm they had faced in the past would also not be equal into the scale. So how to
Yes.
look into it according to
Yes,
your.
I understand your question. That's why I said there's a balancing. We need to go. What was the reason? What was the cause behind it? How much anger might be in the person? They have been struggling since might for long, and we did not. When they don't find a solution within a democratic mean, they may go to express voice in a. Though that act can itself cannot be. Of course, you cannot be pardoned for that, but so far as if we go behind the cause, if we see the suffering on the other side also, then we can do the balance so far as sentencing is concerned. Even in Assam Bamla's case, or for the prosecution, of course, it is always the endeavor that whosoever committed act on violence, there are two theories, reformative and punitive. So I had prayed for maximum, but the judge said these people have faced trial for long period. They were incarcerated in jail, so he did not did not sentence them for death, a sentence of death. He awarded them rather with life imprisonment. But on the other side, you see, they have because this is how, if we are able to balance the things, and certainly some solution would be fine. I think, Dr. Mandal, if I'm correct.
All right, thank you.
Thank you, sir. Thank you.
Yeah, host, I believe we don't have any participants left. We can conclude it if it is so. You are not audible, host.
Yeah. So let's conclude the session. We sincerely appreciate the efforts of all presenters, discussants, and participants. Your research contributions have greatly enriched today's deliberations and strengthened the academic value of this conference. As we conclude technical session 1, I take this opportunity to express my heartfelt gratitude to our respected session chair, all presenters and participants, our contributing institutions, the organizing and technical team. Your support and cooperation have made this session successful. On behalf of CDIPR and organizing committee, I thank you all for your valuable presence and active engagement. We look forward to your continued participation in the upcoming sessions of conference. Wishing you all a very enriching academic experience. Thank you and have a wonderful day ahead.
Thank you. Now we can conclude this session.